Welcome to the Zoning Board of Appeals meeting of December 4th, 2025. At this time, I'm going to call upon everyone to stand so we can pledge allegiance to the flag. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd ask that you all remain standing for a moment of silence in honor of our soldiers, past and present. Thank you. All right. As a housekeeping matter, I need to announce that this meeting is being recorded by Dartmouth Community Media. And moving on to tonight's public hearings portion of the meeting, the first case that we have on is a continued case. It's a use variance. Excuse me?
The next meeting is?
Well, yes. I've just been reminded, I'm supposed to announce that our next meeting will be Thursday, December 11th, here in this room at 5 o'clock p.m. Now, moving on to the public hearings portion of tonight's meeting. The first matter we have is a continued case. It's a use variance. It's ZAV 25-11. It was continued from November 13th. The petitioner in that case is Anthony Malika. The owner is 411 Fons Corner Road, LLC. And the subject property is located at 411 Fons Corner Road, also known as Map 63, Lot 12. We've previously waived the reading of the abutters list. And in this case, for the people here that are in the audience and also our viewers at home, I will repeat that the petitioner in this case is seeking a use variance to construct a fueling station with a convenience store and food service drive-through in an office industrial zone. The proposed fuel station with convenience store is not an allowed use per Article 22, Section 375-22-2, allowed uses, and will require a use variance per Article 43, Section 375-43.3, and also use variance as amended by it's also amended by Article 40, approved 9/10/2014. Okay, so I believe we have the petitioner's representative here tonight. I'm going to ask you to come forward if there's anything new that you'd like to state with regard to this request.
Thank you, Mr. Chair. For the record, I'm Attorney Anthony Malika on behalf of the applicant from Blattman, Bobrovsky, Haverty, and Silverstein. My understanding is that you've given some consideration to this project at the last meeting, and that there's a draft decision that's been circulating. So I guess at this time, I would just ask if you have any further questions about the project or if there's anything else you see fit to discuss.
Thank you. Are any board members have any questions about this petition?
I have none.
So I'm not sure if you're aware, but we did not close the public hearing of this particular application. So
Yes.
we do have an audience here tonight. It is a public meeting. Is there anyone in the audience that would like to speak either in favor or in opposition to this petition? This is one for 411 Fons Corner Road. It's for the construction of a New England Farms type convenience store. So if there's anyone that would like to speak either in favor or in opposition to it, we will be closing the public meeting shortly. All right, so it doesn't appear to be anyone who wants to speak either in favor or in opposition. It's a matter of practice of this board to leave the public hearing open while we read certain findings into the record in case we need some information from you or we need any additional information from anyone else who has a concern, but it doesn't appear to be one. I do have what's been presented as a proposed decision that we could look at and utilize sort of as a template. All right, so gentlemen, do you have a copy?
I do.
I do.
Attorney Faria, doctor? You have one? Yeah. Okay, great. And interrupt me, gentlemen, at any point in time for anything that needs to be corrected, okay? The subject property is located at 411 Fons Corner Road and is further identified as Assessors Map 63, Lot 12. The subject property is located within the Office Industrial District and contains approximately 18.91 acres. 411 Fons Corner Road LLC has owned the property since November 3rd, 2025. The subject property is served by town water and town sewer. The petitioner, South County Development LLC, is proposing to construct a combination fueling station, convenience store, and food service drive-through. A combination fueling station, well, I guess that says it twice. Drive-through. There's a period. Petitioner, South County Development LLC, will transfer the variance to its nominee, 411 Fons Corner Road LLC, owner of the subject property. And 411 Fons Corner Road LLC will be the owner/lessor of all aspects of the combination of uses. Number 7, wetlands exist along the northeast portion of the subject property. However, the plan shows no land disturbance or structures to be located within the 100-foot buffer area. The petitioner is seeking a use variance pursuant to section 375-43.3 and section 375.2.2 for a proposed combination fueling station, convenience store, and food service drive-through. The building department determined on September 4, 2025, that such combination of uses is not allowed and will require a use variance. A traffic statement prepared by GPI Inc., dated November 12, 2025, concluded that most of the traffic entering and leaving the subject property would be from pass-by traffic, and the project is not expected to result in a significant impact on the overall traffic operations of the study area and roadways. The proposed project will comply with all setbacks, building height, lot coverage, and parking requirements as required in the Office Industrial District. And the board, after hearing all parties and the public, finds that the proposed combination of convenience store, fuel service station, and food service drive-through is a needed combination in the Office Industrial District, and that other uses in the district will benefit from the provision of these combined uses. Now, the criteria, gentlemen, that must be satisfied in the General Law 48, Section 10. There are circumstances related to soils, shape, and topography that especially affect the subject property that do not generally affect the zoning district in which the structural land is located. We formulated this as an attempt, but again, I'm open to any interpretation. The subject parcel has an irregular shape. It is very long and narrow, with an average width of 252 feet, creating significant restrictions for commercial use. There exists a significant slope and change in topography on the easterly side of the property. The property is divided by areas of wetlands and poorly draining soils. The soil conditions on the property restrict the areas in which the property can be developed. We okay with that?
Yes.
Moving on to subpart 2. A literal enforcement of the provisions of the bylaw would involve substantial hardship, financial or otherwise, to the petitioner. The circumstances cited above significantly limit the type of uses which can be supported in the Office Industrial District. The board finds that a literal enforcement of the provisions of the bylaw would involve substantial hardship, financial or otherwise, to the petitioner. Denial of the proposed use and trying to accommodate an office industrial use would involve a substantial hardship to the petitioner due to the soil types, the wetlands, and topography on site. Subpart 3, desirable relief may be granted without detriment to the public. The GPI traffic assessment concludes that a substantial portion of the site generated vehicle trips are already present in the adjacent passing stream of traffic, and that the new traffic will equate to less than one new vehicle per trip per minute. Excuse me.
Vehicle trip.
One new vehicle trip per minute along Fons Corner Road during the peak hours. There will not be any harm to the neighbors from noise or lights, as these matters will be addressed in the planning board's site plan review of the proposed uses. The development of the combination of uses will benefit the district by shortening the vehicular trips for food and gas, promote a greater variety of services in an underserviced area, and do so without detriment or harm. Let me just check something out here. Okay. And subpart 4, the variance will not nullify or substantially derogate from the intent or purpose of the bylaw. I indicated that the proposed use as a fuel station and convenience store is in keeping with the intent or purpose of the Office Industrial Use Zoning District's bylaws. And we have the usual conditions where the petitioner and any subsequent owners will secure all necessary permits, and the plans that are on record, the plans that need to be complied with. It's the usual conditions that we impose. Do you have any questions, gentlemen, or any proposals that need, or suggestions?
I have none, Mr. Chair. I think it
I have
covers
none, Mr.
everything.
Chair.
I don't have any.
Right. So, as a matter of practice, we usually move for a motion to close the public hearing at this point in time.
I make a motion that we close the public hearing.
For ZAV.
Oh, you want me to say that too? On ZAV-25-11.
Second.
All in favor?
Aye.
Aye.
Aye, the ayes have it. So, public hearing is closed. What's your pleasure, gentlemen?
I make a motion that we approve the request for use variance on ZAV-25-11, using the facts as stated previously.
And the conditions, huh?
Oh, and the conditions as well.
Second.
All in favor?
Aye.
Aye, the ayes have it.
All right.
Good luck.
Good luck.
Thank you, Mr. Chair, members of the board. I appreciate it.
You're very welcome. All right. Moving on. Well, the next two matters that are on, I actually have to recuse myself because I do have a conflict. Oh, the three matters. So it's ZAV 25-5, 25-8, and 25-9. So I will be stepping down. We will be taking a 5-minute recess.
Okay. The ZBA is back in session, and just for the people who are watching on television, this is the next, for the next three cases, Chairman Medeiros has a conflict, so as the clerk or vice chair, I'll be chairing the next three cases. And the next three cases are for the same property. It's one variance and two variances and one special permit. And just to refresh your memory, these three were continued from October 23rd, 2025. The special permit, the first special permit is, the applicant is Kevin Medeiros and the owner is Louise Properties LLC. The subject property is located at 0 State Road, map 163, lot 31, 32, and 35 in the General Business District. And all three cases were advertised in the Chronicle. We opened at the last hearing, we opened the three cases, and there was discussions from the applicant and the neighbors. The first special permit is for lot coverage. The lot coverage of 91,167 square feet, which exceeds the 2,500 square feet allowed in the Aquifer 3 district, and that requires a special permit per Article 28, Section 375-28.58, prohibited uses. The use variance is for to construct 56 residential units, high-quality residential apartments building on a 270,153 square foot lot. And this is per Article 18, Section 375-18.2, allowed uses. And the second variance is a variance for height on the building per Article 18, Section 375-18.4, development standards and lot size, Article 30, Section 375.30.3, limited business and general business district. At the last meeting, the applicant presented the project, and there was various residents here. I see the faces from last week, and you had some concerns, and mainly the concerns were to do with the blasting, the stormwater, and the flooding, and the traffic. So we asked the applicant to address those issues, and I believe at this time they submitted documents that show that they will be in compliance with zoning, and to address those issues. I believe the applicant's attorney is here tonight, Attorney Markey, if you can just walk us through the traffic report that you have from the traffic expert, and also I have from the professional engineer. I do have a stormwater statement, and also the last time I believe I asked for a map, an aerial map showing the proposed building with the adjacent abutting properties with some distances to the property line or to the residence. And I believe they did provide that map, and probably most likely Attorney Markey will address that too. Thank you.
Thank you very much, Mr. Chairman. And thank you for setting the table as well. And I think your recollection of what the concerns were of the neighbors are our recollection, and we've tried to address them. And just again, to put the, let's see if this went blank on me here. The best intentions here. Let's see if we're doing a little better. You saw the blue screen the whole last time?
John.
There it is. There we go. Okay. So just again, to place you in context, the Wizard of Oz behind me is making things more difficult. Okay, so the concept here is ultimately, although it's called Zero State Road, it is 802 to 808 State Road would be the location of it. And you see that it's on Route 6. And just to quickly walk through it, this is where it would be based on a Google Earth image, and we walked you through the way that it would look. The chairman accurately talked about the zoning relief we were looking for. Now, if you hold on for 1 second here. Let me- hold on. The, sorry about that. Okay. So the first piece is that, for the board to know, after the last meeting, we were able to get the phone numbers and email addresses of anybody who expressed concern. Kevin Medeiros, my client, sent out several emails to neighbors who had expressed concern. One of them was good enough. We only did receive one email question back, was exactly where would the blasting occur, and would it occur in this outcrop of ledge, which is towards the front, and you can see this is visible from Route 6. And I'd say two things. We answered the concerned neighbor directly. This is one of the areas where blasting would occur. The exact nature of whether it was, a circle of 50 feet around this, 20 feet around this, would need to be developed further. And as I explained to them, we're gonna go to the planning board if we are successful with this board, and a lot of those things would have to be laid out in more detail. But this is the location, and I draw your attention to it because you heard in the last decision, one of the things that is often a challenge for applicants is there a uniqueness to this lot? And here, if you drive down Route 6 in that area, certainly there are some rock outcroppings that are down near the restaurant, but this is one of the few that comes up above the ground and causes this unique hardship here. So that's the area of the ledge outcrop, and I wanted the board to know, and the rest of the neighbors to know, that we did hear from one neighbor, and we did try to directly address their concern. And as the chairman said, these were basically the four concerns that we had. What would be, there we go. What would be the concern about blasting? What would be the concern about drainage? And what would be the concerning about traffic impact? And it was easier when I was a high school teacher in the 1980s when you had chalk because it didn't turn on and off like this does. So blasting plans, drainage plans, traffic impact, and a request from the chairman to show our project and how close it is to the neighboring projects. So we'll deal with each of them in turn. As far as the blasting plans, one of the things that became clear to us, we spoke with the blasting company, and my client and his engineer did research, and it is clear for everybody to know, and I want to give you the citation. The State Code 527 CMR has very extensive state regulations if you are going to do any blasting anywhere in the state. They fall underneath the jurisdiction of the fire department of any local community. In this case, that is Fire District Number 3, Chief Richard Arruda, who has done this numerous times during his 20 years as the police chief, and is very comfortable with the fact that he's worked well with a variety of blasting companies over the year, and it is very, very heavily regulated. He is going to oversee it, and he would be able to answer questions for people in the community who have them about it. And he's someone who is not new to this game. He has been doing this for some time. Let's see if the next question was, what would, let's see how this works here. Who would be notified and what is the process? So the process, one of the regulations, is that everybody within 250 feet of the blasting area who has a home is entitled to receive notice and to be offered the opportunity to have your house videotaped and photographed to see what the condition was before anything was done, to make sure that there is no damage to your house. I can tell you that my law office is on the docks in New Bedford, and when they were putting in the new piers behind my office, they came through and videotaped all of the pictures hanging on the wall and all of the joists, so that if there was damage, we would be able to have a baseline. Even though the state requirement was that it's only 250 feet, my client has said there are a number of neighbors who are just outside of that. We are going to voluntarily offer anybody within 500 feet the chance to have that. Some people may say, I don't want anyone in my house, so we're not saying we're going to go into your house if you don't want us, but we're going to offer that voluntarily, and we think that's a sign of good faith because this has to be a two-way street. That we don't want to just do the minimum, we want to do what is going to make people feel more comfortable. So the process would be, once we commit, if we are able, we have a number of steps, as I explained last time, to get through. This just says, can you potentially do the project? We're hoping to get a yes here. We would then have to go to the Conservation Commission, we would then have to go to the Planning Board, and there would be much more detail on all of those, and an opportunity for the public to participate in all of those. But if we would get to the end, the commitment we're making today, that we were willing to put as a condition is, even though the minimum is 250, we'd be willing to do this process or offer it to anybody within 500 feet. And you see the two circles of what homes would be impacted by it. The second question that we had was, what would happen with drainage? So the engineer, Kevin Silva, who is from S&K Engineering out of Westport, basically explained in this language, a representative from SKE Engineering, which is him, he walked the site and observed several deep holes as exposed by the developer. The holes were opened randomly to make sure that you had a sampling to explore both the map of the limits of the ledge and to observe areas where drainage and infiltration could occur. The holes were excavated and viewed by SKE and had suitable soil and a water table. Basically meaning, at this stage, he has not done a full drainage calculation, which planning will require. But at this stage, the concern you stated about potentially what is going to happen with drainage, initial testing has been done, both to check where the ledge was and to check the quality of the soil to know whether things would infiltrate or whether there would be a surface. Again, if you have all ledge and the water all flows downstream instead of soaking into the ground, that could be a problem. And it was the initial finding that this was acceptable. And as he notes in the regulatory references, both site plan review and aquifer protection, he, Kevin Silva, will need to do more detailed testing, at which time he will have to confirm, and it will not just be Kevin Silva testing, as he references here. Official testing will be done in the presence of the Building and Conservation Commission and the planner at that time. So the town will be overseeing the testing that is done to ensure that the initial drainage calculations are available. And just so that you don't feel I'm throwing things on the screen, these were submitted to the ZBA board last week, and they have been available for public review, and they will continue to be available for public review. So as far as the drainage questions that you raised, we went back to our engineer and said, can you please write up a report about stormwater management and about what your initial findings are that will be further developed at the planning board. The third question that neighbors had raised was, what's the impact on traffic? And we have a 31-page traffic report that is also down at the Zoning Board of Appeals for you to review. 7 or 8 pages of narrative, and the rest is statistics and maps and images. But basically, the overall picture is that at maximum, this would be a 2% increase in traffic. And when you look at the traffic that's on State Road, those who would turn right to go on to Reed Road to leave town, or those who would be coming in, it's a minimal change. And I also make the point that this is property that the current owners could develop into a Dunkin' Donuts. They could develop into a fast food place. Those things would be much more intense in the traffic that they drew in and pushed out, rather than people who come in, go to sleep, get up in the morning and leave. This is not a use that is going to be something that is as intense as what might be permitted under the rules. So clearly, you know, we've talked, you've seen it, the people who live in far north Dartmouth, the people who live in far south Dartmouth that have no traffic, and they live on 2-acre lots, that's different than living on Route 6 and living in a very busy section that was designed by the town's planning purposes to be for business and for be high traffic. Adding 50 units of residential is not, according to the traffic study, and again, this will be more fully developed at planning, to cause anything that would be a significant change that would impact people. I'm empathetic to the people who, if you live on Reed Road and it's rush hour and people are coming in or going out, it's not fun. I live near the hospital in New Bedford. I don't like getting woken up with the ambulances, but that's a cost. I chose to live in New Bedford. I chose to live near the hospital because I like the neighborhood, and you have to take the good with the bad. And I don't want to sugarcoat it. You live on Reed Road or you live on State Road, that's part of the deal. And the alternative for these owners is if they want to develop the property for which they paid good money, their other choice is to go in with something that's commercial that would bring even more traffic. And so we think that this report, if, for those of you who want to read it, it's available, suggests that the traffic impact will be minimal. Finally, in regards to the board request, I just want to draw our attention to this. Where are the area homes? So the light purple in this area is where the proposed project would be. You see the driveway coming in off of Route 6. As we mentioned before, it's set back a good distance for two reasons. One is that there's ledge in the front, and the second reason is if we're going to be good at giving good, high-quality living for people, they're not going to want to be right on Route 6. They want to be more set back. So we're doing it in part because financially and development-wise it makes sense, but partly because longer term, it'll be a nice place to live. My mom's 88 years old. She lives less than half a mile from here. To live on one floor when you get older is a nice option to have in Dartmouth without having to do it. If you've got a young person or a graduate student at UMass Dartmouth who wants to be able to live relatively close, this will be a nice option for them. But to answer the chairman's questions, all of the red squares are every structure. You know, obviously this is not necessarily a residential structure, but every structure that is located in the immediate area, to give the board a sense. And I know I don't have the interlay of the 250 versus the 500, but I think the board has a sense from the prior image about where things would be located. So, you know, again, we've come to you and made a full presentation on these 4 issues before. We believe that with the unique ledge that we have there, we meet the standards. We believe that we, in good faith, listened at the last meeting. We tried to address the questions that were raised, that were legitimate questions. The answers they received tonight are not the final answers. If we're successful through this process, we still will have an iterative process with the neighbors, with the town, with the Conservation Commission, with the Planning Board, to get to a final plan. But we think that this is a good use of this property in a town that's trying to develop more housing that will improve the tax base, and that will be a good use of this property. I expect that some of the neighbors will want to talk, and I'm happy to try to answer some additional questions. But before I do that, does the board have any questions that you recall from the last thing that I did not address?
Any?
I don't have any.
I have no questions.
Okay. See if I can get to a blank screen. I'll just step aside. There we go. Okay.
Thank you, Attorney Markey. Before we open it to the public, any questions from, or any discussion, any?
I don't have any at
questions
this
from
time.
The board members? Not at this time? Okay. So at this time, you heard the presentation, and you know what your concerns are, and I believe we took note at the last meeting, exactly what the concerns, and we asked the applicant to address them. And if you heard the presentation, and if you still have, at this time, I would ask anyone who has come up to the podium, either in support or in opposition, or just to state their concerns at this time. So, but please, when you come to the podium, state your name and your address so we can have it on record here, so.
Hello, my name's Karen Ferry, 531 Reed Road. A few concerns with the blasting. First of all, my foundation, I understand you said you'd be taking a videotape. Who's responsible for damage if damage occurs, point blank? The other concern that was not brought up but comes to thinking about is the height. You know, we're giving out an extra 11 feet for height and width. That's taken away privacy from front of our homes, back of our homes. In the traffic report, 2% of what? To who? How many people? You have 2 to 3 bedroom apartments, you have 2 to 3 cars per resident. So it's still so many variables, and I am nay against this. Thank you.
Okay, thank you. Anyone else?
I'm Michael Gilmet, 527 Reed Road,
527?
527.
Okay.
You've already heard my spiel last time, okay? But I want to reemphasize, you know, as far as what is going on, okay? This is not a piece of rock. This is basically a huge, huge cliff that's hanging there. Okay, I looked at the drawings that they have there, and on my side, it looks like they're gonna put 2 tiers of wall there. And to get up that height, each wall is gonna be like roughly around 7 to 10 feet high. So I'm gonna be looking at walls, stone walls in the background. What I'm worried about is, you know, kids falling off, or, you know, even though it's fenced in, there's gonna be problems, you know, with, especially with kids finding their way around this. Also, the view, you can't put any kind of trees or anything in there because it's granite underneath. You know, you may go down maybe 2 or 3 feet, but when the roots hit that granite, they don't have any way of surviving on that. As far as they put in a Dunkin' Donuts, I wish they would put a Starbucks, but we'll see what happens. They got a Dunkin' Donuts across the street. I know it's just an example, but as far as that's concerned, what happens is the major blockage of traffic happens in the morning. Everybody leaves at the same time, either 7:30 in the morning to 9 o'clock, okay? They come home, guaranteed 4:30 to around 6 o'clock. Add 2% of that, else. I'm not even gonna concern about that. I'm more concerned about, you know, the parking lot, having a dumpster right above where my backyard is. When they have the dumpster empty, 7 o'clock or 6 o'clock in the morning when they come, they bang the doors of the dumpster. Wakes you right up. I don't like that as alarm clock, especially on a Saturday, or if you got a day off or anything like that. So that guaranteed happens, and it goes right through, because right now, that is about 20 feet high above this level, so it carries. So everybody in the neighborhood would hear this. There's no stopping it. As far as the amount of people, I mean, you can't stop it. It's going to happen. But as far as tax base, they're not going to get any increase in tax base because renters don't pay the taxes the owners do, and they have a lot sum. You know that. It's the same, it's a different tax base as a commercial or industrial plant. They have a higher tax rate than a regular residential or hotel or anything like that. They get all discounts. As far as sewage, I mean, the water going out, they're gonna have major problems because there's no way of draining that. They can put a retainer pond in it, but there's no room for retainer ponds because whatever is open, it's got granite underneath it. So I don't know how they're gonna solve that problem. I'm sure we have a whole bunch of other issues. We have neighbors, they're gonna have their backyard looking at a 4-story building. That's not fair. They didn't ask for that. They had woods back then. So that's about it for now. For now.
Thank you, Mr. Dumas. Before, I think this, yes, go ahead.
Hello, I'm Christine Donnelly at 209 North Quarry. I'll try to make this quick for the board. Myself and my mother, Laura Lynn, who is sick today, we are against this project. We strongly urge the board to vote no on all reliefs, all the use variance, the height variance, the special permit request, all of it. We request that the applicant build within the confines of the town bylaws, either residential or commercial, no special permits or variances. We request a no vote for all the reasons already stated in the last meeting and because of everything that all of the people who are against it already said. I agree with everything they said, no need to repeat it. Specifically, our home is older, 1909. We don't know about the sustained damage, possible damage that might be not evident during the initial blast. Years, months down the road, we just don't know. The special permit for the lot is way over the 25 and some odd square feet. That's just an insane amount to be asking for a special request. I further request a forego of the vote today so I can speak further with the fire chief for questions about the blasting. And I don't believe a vote is ready because the drainage is not a full report. And one last thing, the height is a serious issue for me. I do very, very close. I'm within I think 100, 150 feet. And so it's 4 stories. My house is here. And it's really, really going to impede on our privacy. And we just bought the lot 2021. So.
I'm sorry, what was your address again?
Yep, 209 North Quarry Street.
Okay.
And one very last important thing is the neighbor at the top of the road is doing a something where he needed to dig. And he just recently needed to dig. And he had to create a huge delay in that project because there was, unbeknownst to him, there was rock and ledge, of course. He just was going to do a simple water line, only maybe about 15 feet down. And it was a severe, it's still, there's no street sign on North Quarry right now because it's still weeks and weeks. It was supposed to take about 3 days. So I think that this project will have some serious delays if it eventually does pass. Thank you.
Okay, thank you. Anyone else? Okay, Attorney Markey, I just have, if you don't mind, go on the,
There was someone who wasn't here at the last meeting, and I just wanted to let them know that I'm not a traffic study expert, but if you looked at the traffic study, it would tell you that This building, based on their studies, would get approximately 218 car trips in and 218 car trips out on a given day with 56 units. That's, people don't just leave once and twice during the day, right? But when you look at what the traffic is on Route 6 during the day, and you look at the traffic on Reed Road, because you know that if everybody comes out of that apartment building, they're not all going to turn onto Reed Road. Some will continue on one way, some will be going back towards New Bedford. So it's going to be less than that that's on Reed Road. No. Well, I guess my understanding would be
Please.
if I left that, I would turn towards Reed Road and I would take a U-turn and head back towards New Bedford. Or, depending on where I'm going, if I'm going to Dartmouth, if I'm going to downtown New Bedford, I might go on to Reed Road. But that's heading out. My understanding of the concern of the neighbors was a line of traffic waiting on Reed Road that made it difficult for you to get out of your driveway, depending on which side you're on. In any case, you ask the question, I want to direct your attention. It's a very detailed report that talks about in the morning, how many trips out, how many trips in, et cetera. That would be useful to you. And I wanted to draw attention to the fact that everybody that came in would largely be coming in either from Route 6 or coming down Reed Road. The preference would be not to have to turn and go down down Route 6 and turn around, so people might be taking Fons Corner. That was one point that I wanted to make in response. In regard to the height, for those who were at the last meeting, you're aware, the height largely was caused by elevator shafts that would be sitting on the roof. It's not the entire building that is imposing above the height requirement. It is 3 stories on the front. Because of the topography, it's 4 stories on the back. And the majority of anything that's above the basic line is the several elevator shafts that would be helpful to older people who were coming in and out of the place. I wanted to just answer those questions directly because I didn't have a chance to meet you at the last meeting, or at least my memory isn't as good because I am 61 now. The other point I wanted to make to Mr. Gilmet is the questions like the dumpster question are classic planning board questions. It really is. We should make it as good as possible to all the neighbors, and we agree with that. But right now, the question is, if my client is going to spend tens of thousands of dollars in engineering costs and in other costs to try to develop and design the project, it doesn't make sense to do that all and say you're not allowed to do it. That process is, we think you might be able to do it, go to the planning board and tell us how you're going to do it. And then all of those practical questions about where should the entrance be off of Route 6? How many lanes do you want to have in and out? Where should the dumpster be located? Those things are all going to be addressed at a future time. So I just wanted to address those 2 issues. And again, I appreciate that you're here speaking on behalf of your mom, but, we tried to address the questions that were raised the last time that others have said. And as to the height issue, I just wanted to reiterate what I had said before, and I appreciate the opportunity.
Thank you, Attorney Markey. I think we want to turn back to the board for discussion on this. I'd like to add, first of all, for the traffic, I mean, unfortunately, most of us here don't understand traffic, but I understand traffic. I deal with traffic every day. I just wanted to assure you, and I think I spoke last week too, any retail or commercial project, small restaurant or fast food or a drive-through would generate 4 or 5 times the amount of traffic of this residential. But I wanted to make sure that you wanted to hear it from the professionals and from the experts. That's why I asked for traffic. As far as stormwater, we have regulations in town, and the state has regulations too. You can't cause any flooding to adjacent properties. There's DEP is regulated by DEP, regulated by by local stormwater bylaws. It has to be reviewed by the planning board, it has to be reviewed by engineers, and they might ask for a peer review too. Hire another third party to do a peer review on the design of the engineers, on the applicant's engineer. So it's not something, and as a board here, we're not here to approve. This is their first step. If we approve this tonight, it doesn't mean they can go tomorrow and apply for a building permit and have a shovel in the ground in a month or two. It's a long process. They still have to go through boards and state agencies and address the stormwater issues. Again, the blasting is also regulated by the state, and because this is Route 6, it's a state highway, I believe they have to apply for Mass DOT also for this, beside the fire. And the applicant said, regulation says they have to do a pre-construction survey of 250-foot radius, and being a good neighbor, he volunteered to do 500-foot radius. And I think this is gonna be a condition probably on added to our permit if we grant this tonight. As far as the height, I understand. And as Attorney Markey stated, I looked at the plans. The third floor elevation is 31 feet. It's in compliance with the zoning bylaws. The elevator shaft is higher, so it's not somebody sitting on the roof, sunbathing or whatever, looking at the neighbors, you know. It's not, it just access, they need the shaft for mechanical aspects for it to work. They need the shaft to be on top of the building. And that's why we have special permits and variances, and that's why we have zoning board of appeal. With all respect, you requested not to grant. It's not to grant. We don't grant variances and special permits just because we want to. We look at every case by case, and we look at the constraints, we look at the site, and we look at all these things before we make a decision. So same as you have the right to object to a special permit, the applicant also has the right to apply for a special permit. So, but we wanted to make you feel comfortable. We want, you know, you're the neighbors. Again, you live there. I don't live far, trust me. You know, I drive, but I live off of Reed Road. I know the area exactly. I drive by every single day. I see the restaurant. That restaurant that is there, I guarantee you, generates 3-4 times the traffic of the 56 units. You know, so this is in regards to the height, to the traffic, to stormwater, and also I think Attorney Markey, you have the large plans that shows the aerial mapping, and I believe the closest point from the proposed building to the property line is somewhere around 101 on the east is 167 feet, 167 feet. The one to the north is 190 feet. And to the west, it's a little bit closer, 150, 145, but also there's a vacant piece of land in between because it's all wetlands, it's undeveloped property. So you are close, but you're not that close. I mean, you are in a butter, but it's not a building that is going to be 40 feet, 50 feet, or 60 feet from your property. With my guess, I would say the closest residence or existing structure would be probably over 200 feet. Am I correct?
My understanding is you were describing initially from the property line, and the building is
Right,
not
no,
right on
that's
the
what I'm
property line.
saying.
So the actual building is off of the property line, so it would be exceeding 200 feet.
200, that's what I meant.
And then one other point that I had forgotten to make, and I apologize. If there is an issue with blasting, the blaster and the owner is responsible to you under tort. And there's two good lawyers on the board that might take that case. Mr. Human or Mr. Farrier are both lawyers and they can explain to you. If it's an intentional act that causes damage to another, it's no different than a car accident. And that's why we do the testing before, and you'd be able to prove what happened afterwards. And I know some people have said, well, who knows, 15 years later, maybe this was one cause of later problems. I can't speak to that. But I can tell you, if there's an immediate problem, you have a lawsuit, we're responsible, and the blaster is responsible. And that's why the state regulations require the blaster to both be competent and reviewed, and also to have sufficient insurance to cover any damage, however minor or however significant.
I wanted to address also the dumpster, because I understand, you know, I do a lot of development with gas stations and convenience store and drive-throughs, and some of them are abutting residential areas, and people are concerned about traffic, or maybe gas delivery at night, or, you know, the dumpsters. I think I'm not sure if the planning board, you're going for a site plan review, not a special permit. So I'm not sure if the planning board can place conditions on the site plan review. If not, this board can put conditions on the dumpster pickup that should be in certain hours. So should be probably between 9 a.m. to 4 or 5 p.m. So it's not somewhere at like 3 o'clock in the morning or something like that. If this is something that, if the planning board doesn't have that jurisdiction with the site plan, I'm not sure. Because you're going for a site plan review, not plan,
We would be open to you basically saying, we defer to the planning board to choose, but if they don't, these are our hours that we would impose. If you write
That's
that as a
fine.
condition, and then the planning
Absolutely.
board can do it if it's within their jurisdiction, because they have more experience with it. And then if not, you have the. you're-
Yeah,
you're the
suggestion
backstop.
that between certain hours, I think. That's my,
Mr. Chairman, I think there's a gentleman who wants to address this again.
absolute, Mr. Dumas. Is it Dumas?
As far as the height is concerned, I remember years ago, I'm sure you'll remember this, when they put in Macy's. Remember Zayres before that? Single floor, it was a 14-foot high ceiling, and they put the 2 stories, and they wanted to get a zoning variance for it, and they had a tough time getting through. The only way they could get away with it is they stipulated that there'd be a skirt on the top of the roof hiding those 2, whatever the air conditioners, in their case, they had air conditioners. So if they put a skirt on the top, a design skirt, obviously, not just like a wall or something like that. I'm sure they have that at the hotels across the street. They have the same similar things, just to cover that portion of it.
You're referring to mechanical.
Mechanical, yeah.
Right, that would be, with this building size, I don't think you will see it unless they place it right at the edge of the building. But if it's set 20, 30 feet from the edge of the building, you're never going to see that mechanical unit. But
10 feet.
But again, I think this would be, when they go for, with the planning board, they do these,
I believe they did that in the appeals back then.
We
they
can
put it in.
add, again, we can add another condition that they have to screen the mechanical on the roof. If the planning board doesn't have the jurisdiction to do that, we can, same as we did with the dumpster. It's not an issue. We do it all the time. We do screen them, and like I said, the only way you'll see it if it's close to the edge of the building, but if it's set.
If you just close the
you know,
building, you're not going to see it up there. It's
You're not.
further back, you see it.
I don't think, trust me, but
I'm gonna bet
with that
you-
size building,
Yeah, you're going to
okay.
see it 10 feet.
All right, well, again, this is, I don't think the applicant is opposed to this, because they'll have to go through this with the planning board anyways. And again, we're here to address your concerns as the first step, and this is not granting a building permit tonight, so you can understand that. Thank you.
I had a simple question. I want to know, is there any way that, I don't know if it's called a condition, but 6 to 8 weeks after the blasting is done, can somebody come back from these special people and kind of see if there's anybody who wants that? Because I would want that. I'm one of the ones that's about 150 feet. I'm the one that has the little triangle piece of land in between at 209 North Quarry. So I just, I'm not talking about 15 years later. I want to know, if something settles or a crack happens or something terrible. So that's my question.
Yeah, Attorney Markey, I'm not, it's regulated by the fire, but I'm not, at
It is
527.
regulated by the fire code that when they do the post inspection. I don't know whether it's 2 weeks or 2 months.
I'm not sure
So
either, that's why.
I will defer to them to say they do it at 4 weeks or 8 weeks or 2 weeks because it's the right time. I can assure you, we're here, we know who you are. If they come by 3 weeks later and there's no problem and you notice something, if you contact us, you have the claim that she described, and we'd be happy to come back and take another look on an individual basis. But I don't want to promise to do something twice when the state says the right time to do this, when things settle, is 3 weeks, 6 weeks, 9 weeks. I don't know that off the top of my head because I'm not a blasting person. And just to, one other point, Mr. Guillemette, things like appearance is classic planning board. So I'm happy to say limit hours and have this board impose hours on us. But things like screening and what does it look like and do you like that? That's the whole purpose of going to the site plan review on the planning board. So I'd prefer if this board would say, yeah, on hours, don't make noise, if they can't do that. But on the other issue about what would look nice, what looks nice to you might not look nice to me or to another neighbor. So I don't want, personally, I'd prefer that not be a condition coming out here, not to push back too much, just generally speaking. I'm sorry, I just wanted to address both of those issues, but I don't know if I responded to your.
Well, yes and no. I just want to make sure that I can like touch base with you at some point or somebody, Pierre, because, you know, these meetings go quick and then boom, we're done.
And two things. One is, there will be no blasting until, not only are we through this process, we would have to go through the entire planning process, where they talk to us about what they want the lighting to look like so it doesn't disturb neighbors. How do we want the traffic flow? Where do they want us to do plantings of trees to give screening for people? There's a whole bunch of things that happen in the planning board process that are much more micromanaging than what this board would do. And that would be a time when you could, you're gonna see us many times. It's not as if the blasting is gonna happen anytime soon. So yes, we are happy to come back again. We will follow whatever the regs are for the post-testing.
I'm so close. I'm one of the closest ones,
No, I'm not.
within what he was just speaking about.
And I'm not suggesting you shouldn't have a concern. I'm not suggesting you shouldn't ask the question.
I don't want it to be dictated, oh, well, we're
Okay,
coming
but
once.
we can't have an open conversation, please. So,
Oh,
yeah, I mean, let them finish, and then if you can, again.
Yeah, no,
So,
that's all. Just I don't
yeah,
want it to be dictated.
This is the
that's all.
first step, and I think the blasting won't happen until they get a building permit, I would assume, before they start the excavation. So that's, with project with this scope, I would say this is 6-8 months from now.
It's just
or, you know,
nerve-wracking,
so-
that's all.
Yeah, no, I mean, you'll have all, this is a public hearing, everything is on record, you know, you can get a copy of the minutes, and you're on record what you said, and he's on record what he said. So
Thank
it's
you.
not, we're not disappearing tonight after the hearing, so, okay? Thank you. I think we're good at this time. We heard the neighbors, and we heard the neighbors' concerns, and we heard the applicants.
I'd like to make my final statement regarding this.
Sure, if you can make it quick, please, Mr. Thank you.
With all due respect, okay, the reason we're bringing up this subject of the skirt, you are required to give this person permit to build higher, okay? If he's building higher, you have the right to say, okay, we want something in return. The building, planning board, they stamp, no, they do their thing, but unless you put that in writing on your part, because you're giving them permission to go higher. Okay, so that's a stipulation.
Okay, all right, thank you. I believe even if they're not asking for the height, when they go for site plan review, the screening is part of the review. But again, you're right, because they asking for variance on this time. We'll make sure that screening is addressed, whether from this board or from the planning board, the screening will be in place. So that would be part of the, if one of the conditions, or deferred to the planning board, like the same as the dumpster and the, yeah, like the dumpster, the hours. Attorney Human.
I don't have anything to add. I mean, I've heard everything that everybody has said. I've heard what Attorney Markey has presented. I don't have a problem with the project.
Attorney Fudge.
Mr. Chairman, I don't have a problem with the project, and I just wanted to emphasize here that this board, since I've been involved in town politics, and I think it's probably 100 years, this board, we serve to protect the people the town of Dartmouth. And I think that, I'm seeing some confusion here, but as sitting as a board member, I would like to address some of the problems that are addressed here, but we don't have the jurisdiction. This property, from what I understand, I believe, and I may be wrong on the zoning, whoever the owner is, could put a motel there. And they wouldn't have to come before this board. You could have a hotel there, you could have a restaurant in the hotel, and I'm gonna tell you something, I'm not a traffic expert, but an old friend of mine once told me, you don't have to be a weatherman to know which way the wind blows. And what I'm saying is, if, I don't even wanna go on Route 6 sometimes. The other day, I had an appointment, I had to go by the mall, and I thought people were Christmas shopping, probably they were, there's so much traffic out there. But this project isn't gonna, I don't think it's gonna cause any traffic problems, any additional traffic problems, because a motel, a Dunkin' Donuts, these are uses that are allowable that we have no control over, at least this project. And I would also say, Mr. Chairman, I think even our involvement is in a limited way. You know, they're asking for a use variance, only because they want to put residential. They want to put, as I say, a motel, they wouldn't be here. And nobody's gonna tell me that
Or
if the
retail,
Dunkin'
or,
Donuts, yeah, retail, whatever, but
restaurants
there's
or-
gonna be more traffic in any other project that I see of a motel, and I wouldn't, honestly, I wouldn't wanna be living in that area, because you know, I have a little place in Miami Beach, and I can't even get in my car and drive down the road, because there's too much traffic, and it's ruined everybody's quality of life. And we're facing that in Dartmouth, that in certain areas in Dartmouth, the quality of life isn't what it should be, but it's there. We have to try to deal with it. I mean, I wish I could ban automobiles. That's not before the board. As I said, I hate to get in an automobile and drive, especially on Route 6, or now on Tucker Road to get to Route 6.
Actually, that location has public transportation. There's buses that go by
Yes,
there.
that's another-
So
yeah.
that's another thing that we need to,
I
you know,
think
so.
at some point in time, I've made a statement the other day, I said, 10 years from now, people won't be driving cars, they'll be taking trains and buses because too many cars on the roads. And you can, I was a selectman in this town from 75 to 85, I think, and in 75, all we heard was expanding Fons Corner Road, improve it. We're still improving it. It's 2025 and it's still going on. There's more traffic on Fons Corner Road than ever before. I'm seeing the same thing as traffic on Dartmouth Street, where there's a lot of development. I live in South Dartmouth, and it used to be going home was a pleasure, but there's certain times you go home on Dartmouth Street, the traffic's horrendous. And most of it's commercial, but I think that I've listened to the concerns, and I'm here because I want to listen to the concerns, and I think they're legitimate, but some of the things about the dumpsters, there's going to be dumpsters there, whether it's residential or commercial. And I think the chairman said there's certain things we can do about the dumpsters, the time, but they're going to be there, unfortunately. And again, the traffic, the stormwater, there's going to be stormwater problems that really is not a purpose of this board here. And as far as the height goes, I don't see, they're in compliance, they're building the plans I saw. It's because of the elevator shaft that causes it in non-compliance here, but again, if it was a motel, we wouldn't even be here, we wouldn't be able to listen to you. Let's start the construction, and the blasting, that's another thing that's not in our jurisdiction. You know, I guess we can put certain restrictions, but the state,
I'm sorry, you need to come to the podium if you need to speak, but,
Hotel or not, or residential, as neighboring, we would have to be notified of blasting.
well, not from this board. You wouldn't be up here having a
The town of
podium here and
Dartmouth?
talking to the board.
From the town of Dartmouth. We wouldn't have a board.
I think it would just be the 250 feet. And I don't know whether you're inside of that. There were very few that were inside the 250, which is why we
And
expanded.
it sounds like the
to 500.
decision's already been made, so I'm just kind of confused.
no. if the decision was made, it would have been made last time. We asked for professionals, experts' opinions, and that's why we're here. And that's why I said I wanted you to hear from that, not from us. Even though I could have told you those things, I'm an engineer myself, but I'm not doing that. So I think at this time, we're not going to close the public hearing, but we're just going to have a quick discussion. It seems like the board is inclined to grant those reliefs for both the variances and the special permit.
Yes, I'm in favor of it.
At this time, I think, Attorney Markey, I would ask you if you can write a draft decision for the board for the 3 cases, and please include addressing the dumpster and the screening in a way that if the planning board doesn't have the jurisdiction, it falls back to us. So, and for hours, I think maybe 8. I don't know if you want to pick time for the dumpster, or just in case the planning board deferred back to the zoning board. I think 8 to 5 is reasonable.
Sure, whatever your pleasure is.
Yeah, I mean 8 to 5. This is during the week. I mean during the day. Nobody's sleeping mostly, after, and still early enough. People not having dinner, or so we understand. You live there, so we understand. So at this time, I would ask to continue, but Michelle, what do we have for, I think, January? January 8th. January 8th? Well, okay. Yeah, so that's, next meeting's January 8th, so you'll have something probably to Michelle maybe a week before, or 4 or 5 days, so we can take a look at it. And
I won't bother on New Year's Day, but I will get it to her 4 or 5 days in advance.
okay. So, Attorney Newman, you want to make so we need to make a motion that we continue the 3 hearings, and you probably have to write them.
I make a motion that we continue the hearings on ZSP 25-5, ZAV 25-8, ZAV 25-9 to January 8th, 2026.
I'll second that motion.
All in favor?
Aye.
Aye. Okay, see you on January 8th. Thank you.
For the members of the public as well, is it 5 or 6 o'clock that night, or do you know yet?
5.
Okay. Thank you very much.
Thank you. At this time, we'll take a 5-minute recess.
The zoning board is back in session. Moving on to the last matter that's on the agenda for tonight's meeting is comprehensive permit ZCMP-25-1, continued from October 23rd, 2025. The petitioner is Paul Cusson. The owner is Bliss Investors LLC. The subject property is located at 970 Tucker Road, known as map 46, lot 2, and it's located within the single residence B district. This matter has been legally advertised, and we've waived the reading of the abutters list. The petitioner is seeking a comprehensive permit pursuant to Mass General Law, Chapter 40B, Section 20-30, and the comprehensive permit guidelines. And they're looking to, on the 56.3 acre site, to name it the Residences at Hawthorne, to be located at 970 Tucker Road. Development will have a total of 147 homes. I think that's been somewhat adjusted, but we'll adjust that again here tonight. 117 single-family homes and 30 duplex units, consisting of 15 buildings. I'm not going to read all the different code sections. We've read that before. So at this time, I'm going to call upon the petitioner, unless there's anything else we need to address. I'm going to call upon the petitioner or the petitioner's representative to come forth and explain to us where we're at.
Thank you, Mr. Chairman. Paul Cusson, Managing Member of Delphic Associates. At this time, what we would like to do is there's been an engineering report submitted by your peer review engineers, and Christian Fallon from Fallon Corporation. We have not had the opportunity to complete the entire review. We just got that not too long ago, but we'd like to bring the board up to date, and then there'll be a full formal response to that review. So Christian can.
Well, in the interest of time, what is it about? Is it about traffic?
Well, we also have, my understanding is that your traffic peer review person is not here, but at the last meeting, we were asked to take a look at another section of town on the corner of Allen Street and Slocum Road. And we have done that, and there has been some communications going back and forth between your peer review and our engineer regarding that particular intersection. We can bring the board, if you'd like tonight, just up to date on that particular intersection.
I don't need that. No, I'd
Or
rather
we can
move
just
on
put
to-
traffic to the next meeting.
Yeah, I'd like for the next meeting.
Fine, okay. So tonight, we're just going to talk about the engineering that's been brought up to date and somewhat of a response verbally to your engineering peer review that was received by Niche Engineering.
Okay.
Okay, and the development has been changed, and Christian will get into that, from 147 units to 138 units.
It's 138 at this point.
138, and the reason for the change is primarily, as Christian has been developing more and more of the engineering, it's necessary to accommodate certain issues. So so it is 138 units that he'll be talking about. Christian,
Does it, excuse me, Mr. Chair, does it make sense, though,
We should
to
probably
have the board's peer review engineer give an overview of his letter first?
I think
So
it
that
probably-
the board and the public can hear what
Yes.
his findings are?
I agree.
Fine.
Thank you. So, a gentleman's from Niche, right? What was his name
Mr.
again?
Gabriel?
Yes. How are you? You're on the hot seat. Kindly identify yourself, name and address.
Absolutely. One second here. Mark Gabriel, for the record, with Niche Engineering. All right, peer reviewer for the town of Dartmouth here for the residents of the Hawthorne project. So just briefly, I had submitted a peer review letter on November 14th, and just going backwards in time a little bit, we received some plans on October 13th through the town of Dartmouth online portal, the engineering plans and the stormwater report to do the peer review on those plans. As you mentioned before, we had our meeting on October 23rd, 2025, where we got to hear testimony of the project and hear from the abutters as well. And then on October 28th, 2025, I was able to go visit the site, do a site walk with Mr. Barber, and just see what exists there today. Leaving the hearing on October 23rd, we were requested to submit the peer review letter no later than November 22nd, and we did get the review letter out on November 14th. So we met the deadline that the board had asked us to meet. If you believe you all have had a chance to see the letter that was uploaded to the website, just briefly going through the contents of the letter, we have a scope of our peer review. We go into the information that was gathered and reviewed, and before that, we do have an executive summary of the peer review, which I'll talk about very shortly. And then we get into our site and project description, just kind of understanding what resides there today and what we were seeing with the materials that were submitted. And then from section A through F, we broke it down into different sections of the peer review, with section A being, some comments that we had on permitting, section B being our comments in regards to the Town of Dartmouth comprehensive permit regulations. Section C, we get into more of the Town of Dartmouth subdivision regulation requirements, because this is a subdivision that's being brought before the board. Section D are just general plan and report comments that we come up with. And section E is in regard to the Mass DEP stormwater management standards and how the project complies with those. And then section F, the last section, is just the Town of Dartmouth stormwater rules and regulations. So I will not read the executive summary verbatim, but generally, the review that we had, as I mentioned, is focused on the site development and the stormwater management. and how it complies with the Town of Dartmouth subdivision rules and regulations and the stormwater regulations, as well as the Mass DEP standards. The submitted plans in general and the drainage report, they generally demonstrate project feasibility, but do require additional detail to confirm constructability and regulatory compliance. A few of the points that we brought into executive summary, the first one being, just about emergency access and how the subdivision consists of what at the time was 147 units, is now 138 units, with access on a public roadway with a single dead-end roadway, approximately about a half mile to the furthest unit from the entrance. With there being only one public roadway entrance serving these units, emergency access may be inadequate, and we'd recommend consultation with the Town of Dartmouth Fire District 2 to have that discussion with them and go over that with them as well. In regards to documentation, there were some documents that were still required and per the municipal regulations and bylaws, and there was some missing or incomplete information there that we just asked be addressed. And for the stormwater management, there were a few gaps in the report in regards to some forms needing to be completed, some calculations to be updated, and some additional data to be provided so that we can confirm the necessary information for regulatory compliance. That said, I don't think I need to read this report unless you want me to, but otherwise, I'm here to help answer any questions on the letter that I provided.
Gentlemen, any questions?
Not at this time, Mr. Chair.
Not at this time.
So with regard to the emergency access, what has been submitted to us that would allow for them to have some sort of egress or ingress for emergency purposes other than the main entrance?
All I've seen, the main entrance, and then there is a secondary egress onto a private roadway off to the south of the site. South of the site there.
You're there?
Yeah, and there weren't, I didn't see any preliminary turning analysis either for the fire trucks. There was a request on a reduction of the cul-de-sac dimensions from the subdivision regulations. So we were just looking for some preliminary turning analysis to confirm the trucks can make it around those. And the roadway width was reduced from the subdivision regulations. There was a waiver request to reduce it from 24 to 22 feet wide. So again, just making sure the turning movements and adequate emergency access is provided to the subdivision.
Excuse me, Mr. Chair, so during the initial traffic presentations, that was one of the first hearings, counsel for the applicant said he was going to be submitting a memo to the board explaining why they think they're allowed to access a private way as part of their development plan, and that hasn't been received yet. So it sounds like we still don't have any information as to why they think they can show that as their emergency access.
But they do have some updated information. I think they're going to present it to it tonight. Maybe they can address some of that.
Yeah.
Okay. All right. If there's no other questions, I think that's all I have for now. But obviously, you're here. Anything that's raised, we can obviously bring you back and sort of ask you for some guidance.
And I believe the next steps will be, as Mr. Cousins was saying, there'll be a response to comments, and we'll address those, and happy to do a second peer review at that time.
Fair enough. All right. Doctor's not here. So I think we can move on to the expert for the petitioner. You can identify yourself, please.
Yes, good evening, Mr. Chairman, members of the board. For the record, Christian Fallon, Principal Engineer and President of Fallon Corp. We did receive the peer review comments from the town's consultant. We certainly appreciate the time put into it and for expediting that review over to us. We're anticipating having a response back by December 19th, which will be submitted to the town. What I would like to do, my purpose of tonight's presentation is just to provide some context for the design level of the plan submitted, what's typically requirement of 40B, comprehensive permit, and how our submittal certainly exceeds those requirements. It's important to emphasize that this project is being reviewed under MGL Chapter 40B, which certainly is significantly different than a typical residential conventional subdivision or a site plan application that you would normally see. Under the 40B process, the intent is to provide conceptual to intermediate level design plans. Typically, they're only around 30% drawings, which demonstrate feasibility and compliance with safety, environmental, and engineering standards. The applicants are not required to submit full 100% construction drawings during the permitting stage. Detailed engineering is traditionally completed after the board issues a comprehensive permit and after conditions are established. The stormwater design will have to go through the permitting process of a notice of intent, which is under the jurisdiction of the Conservation Commission. This structure avoids unnecessary redesign, unnecessary cost, and allows the applicant to finalize detailed engineering in alignment with the board's conditions. Although 40B only requires 30% design, the plans that we have submitted to the town are approximately 70% design. So that's why I feel they certainly exceed the requirements on the state level. The plans presented have roadway layouts, grading, drainage designs, which are far more advanced than typical 40B conceptual level drawings, stormwater basins, pipe networks, and hydrology that have been extensively engineered, not simply sketched out or conceptual. Utility layouts, building placements, and access designs have been developed at a level approaching near final design. Many elements in the peer review are typically addressed as part of the board's conditions. In other words, the plans submitted go well beyond what is required and expected at a 40B design level. Because our plans are already close to 75% design, the peer review comments we received primarily consist of requests for clarifications, requests for additional documentations, and suggestions for refinements that can be addressed through standard permit conditions. Nothing in the peer review indicates that the design is unworkable. The comments reflect typical refinement items that naturally arise as plans progress towards 100% construction detail.
Can I just stop you for a minute?
Sure.
That plan that's up there, is that the one, is that with 138 units, or is that the original one with 147 units?
This was the plan at the last meeting you asked us to revise, so this reflects the current plan set that you have, the 138.
Okay. And if you want to get to that later, I apologize, but I was looking at that, I wanted to get a sense. What has, I've not seen this one before, but I've seen the other before, and I don't know where the biggest changes have occurred there. Are there increases in lot sizes as a result of?
The biggest changes were from the, can't see it, but you see the blue areas?
Yeah.
Those were the detention basins that were added.
How many is it, 3?
Altogether, there's 10.
How many was it before?
3. We had these big ones down here. There's another one behind the community building. And then these in each kind of development, the reason why we need these is because there's a lot of flow behind the houses. Instead of having all that flow go directly onto the street and go into a catch basin, catch basins can only typically handle about 20,000 square feet of area. So if all that water went into the street, they would just bypass the catch basins and go all the way down. So we captured a lot of that water in between the houses with these detention basins here, which they fill up, they slow the water down. There's an outlet control structure that goes back into the drainage system. So that was the main reason for the reduction of the number of lots, dwellings. Is that good?
No, thank you. Sorry if I broke your train of thought.
No, it's okay. So even though the plan set, as I mentioned, is more detailed than typically required, it's not worth going into 100% design level at this point. And the reason for that is because the board may impose conditions that require modifications to grading, drainage, or layout. It's inefficient and costly to finalize detailed construction drawings before knowing the board's conditions. And the comprehensive permit process is structured so that detailed engineering is completed after permit issuance, then reviewed and approved by the town staff and/or peer review at that stage. So there will be another opportunity for the peer review to review the final set of drawings. This is the same approach that is done not just here in Dartmouth, but throughout the entire state for a 40B project. In regards to the peer review comments, we do want to assure the board that we will respond to each peer review comment in writing. We will provide revised plans where we feel it's appropriate. We will supply an additional calculation of supporting materials needed. We will finalize a waiver list from the subdivision regulations and 40B comprehensive permit requirements so that the board knows what standards apply before voting. And we certainly will work with the town to refine the plans as they progress from 70% level now to a final design. Again, I just want to summarize that this is a 40B application where typically only 30% drawings are needed. At this point, the peer review consultant and board should be confirming that the stormwater design works in a concept level, the site access is safe and feasible, utilities are serviceable, and the waivers are clearly identified. We feel our plans are certainly far enough along that once we make the response to the peer review comments, we feel the board should have a pretty good understanding and capability to be able to vote on the project. Since the last meeting, we also submitted to the town the water and sewer flows. That was a memo that came in from Apex Engineering. They will be doing the design on the connection to the sewer line, which is a 27-inch sewer line that runs along the westerly side of the property. Has been determined that there's plenty of flow for that to handle our additional flow going into it. I don't think we received anything from the town's consultant in regards to the sewer and water yet. But certainly the plans are far enough along to demonstrate where we're tying in with the water and the sewer. And that wasn't part of the peer review from Niche Engineering, but we just want to let you know we did actually do that work, and that is completed. In regards to the emergency access, I mentioned this in one of the first meetings, that we did meet with the fire chief, and they had no issues with this project. We feel, as far as the fire, we're not looking to access, nor do I think any of the abutters want us to access the road down on the south side here. The only thing that would be coming off of this would be a fire truck or an emergency vehicle. So we don't need permission, nor does the town or emergency vehicles need permission to do that. And the fire chief said that to me directly. They can drive anywhere they want in town, whether it's a private road, public road. The most important thing here is public safety. If there's an emergency, they're not gonna ask for permission. They're gonna go ahead and do it. And that's normal throughout the state. We don't need permission for a fire truck to do that. If we were using that as an access road for our residents, then that would be a different story. But we're not asking for that, nor, I don't think any of the abutters here want to see the traffic going through that property. That's all I have for tonight. I'll be glad to answer any questions that the board abutters or consultant may have.
Mr. Farland, I heard everything that you said, but the last few statements that you were making about the ability for a fire truck to actually go upon someone else's property, you know, those are in exigent circumstances. You're allowed to do many different things that you normally wouldn't. But this is a planned subdivision that you're seeking approval from from a local authority, which is the zoning board. I have never seen where we've ever approved any type of a 40B project that didn't have. The last one that we did was the Preserve in Dartmouth, and they had a designated emergency access area in which they had continuous ownership of the property right up to a public way. Now, it was designated for emergency purposes, so it was closed off, maybe with some signage. I don't know exactly what we approved, but I know that that was approved. It hasn't been built yet. They're in the process of building it. But to say that we're going to approve and allow and accept an emergency exit to be one in which it'll be designated as such on your property or this subdivision, and then thereafter, to get to a public way, it crosses over some other private property owner's property, that's not gonna work. I don't see where that's gonna work. And I see Ms. Thompson, and this is an area I know a little bit about, so I consider myself a real estate lawyer, and I will say that that's not something that we could approve. So I don't know how that's gonna happen here. I leave that upon you guys, who have a lot more expertise in preparing plans that you're saying is 70%. You certainly say that to me. I don't know if it's 70%. I would turn to him.
Or the peer review.
Or a peer review to determine are these things at 70%. I don't usually.
They actually only have to be 30%.
No,
Excuse me? I
So,
understand that.
excuse me, there is nothing in the 40B regulations that state that plans only need to be 30%. That is not in the
I
regulations.
don't want to get into the percentage
So
argument, and I
it's-
sort of brought it there. It's just that he's saying it's 70, that's great. If he says it's 70, I don't know. But I think he's saying at minimum, in order to present, is 30%, and he believes that he's exceeded that. I don't know that. I don't know about how these calculations are made. I'm presuming that there are other plans that have drainage calculations, that so how many gallons are gonna be flowing, is sheet flowing, whatever else. And that's one of the reasons why they've had to put all these detention ponds in there to accommodate that, and that's certainly lessened the numbers. I'm not saying that, I'm not believing or thinking that they're kindly reducing the numbers. They're doing so because they need to. And that's well within this process. That's why we're all here, right? That's why we're all here. So I guess getting back to this issue of an access, emergency access area, I don't see, and I don't know what type of, I'd like to see what type of legal authority someone's gonna present me with that says that a subdivision that's being presented can have and designate an access area that doesn't have direct access to a public way, but over a third party's private property rights without some written easement or something else in place. If they have that, that's fine. We're still in the infancy stages of this, I get that. And maybe they're gonna have that, but to say that that's what it's gonna be, that's gonna be an issue,
Mr. Chairman?
absolutely.
Paul Cusson. The property, we have legal access right to Fairway Drive. We're not crossing any private property to get to Fairway Drive. So our property line abuts the property line for Fairway Drive and that
So let
particular
me ask you,
development.
so are you gonna request a curb cut along Fairway Drive?
No, the
as
fire
part-
chief, the fire chief in an email that he sent suggested as to how that should be built, and we would comply with whatever the fire chief wants in the
I'd
way
like to
that it's
see
been
that.
built.
Do you have that with you?
No, it was I don't have it with me, but it was submitted to the board, and I can get you another copy.
Mr. Chair, may I?
So,
Hold on. I hear a lot of comments. We record this, and these microphones are actually ultra-sensitive. Any background noise, it's all picked up, and she needs to translate all this into meeting minutes, and it becomes a little complicated. So she's already asked me on more than one occasion. I haven't been as compliant, so I'm trying to be compliant today. So I ask you, so I don't have to be blamed for it, that we just keep it to not even a mumble, but just not even a little rumble, mumble, nothing. If we could just not, I'm gonna give you an opportunity if you wanna come up and speak. To be honest with you, I don't know how much we're gonna be able to speak to you about tonight, because we still are up in the air on some of these issues. There seems to be a lot of comments and suggestions that our peer review expert has, and they haven't addressed that yet, which is fine. This stuff it takes time, right? I get it, it takes time. We don't rush to any of this, and hopefully, we'll have more answers the next time that we're here. But back to you.
Thank you. So I will see if we can find that email that was submitted by the fire chief, in which he also recommended how it's to be built, and we're still willing to obviously work with him. But our intent was to leave that egress up to the board. If the board felt we're showing on this particular plan, we are not showing access, we are not showing an emergency egress out onto Fairway Drive. Christian, can you show them where the...
Yeah, I know the area, it's just, I don't know who,
Right, so
it's kind of cut off there, I don't know if that's just.
that's
I
part
just
of
see a
the...
roadway there, I don't know if it's conveniently cut off there, but it's just not there, it's just a big white little triangular, large obtuse area there, but I think it's where the shrub line kind of makes an indention there. Let's say that that's the southeast corner of this parcel.
The property line is identical.
So you're saying that the property line of this particular parcel, this entire parcel, actually abuts Fairway Drive?
Correct.
Okay. All right, well, that's,
Plan, it shows just a cul-de-sac at that area. And the fire chief has recommended a secondary means of egress. And in his email, he suggested what should be built, like a breakaway fence, and that's still up in the air as to the best way he would want it done. And that would be just on the property line. So the only way, and I've checked, I didn't have an opportunity to speak to the fire chief in District 2, but I spoke to the fire chief in District Number 1. And he confirmed to me that for emergency purposes, a fire truck can go where, or any other emergency can.
that is, I agree with that as a
Okay.
general statement.
Yes.
Okay, as a general statement, I agree with that. But the thing is when you're designating a plan, right, when we're coming before this board, seeking approval, and we know that we need access for emergency purposes, we don't just leave it open-ended where you're just gonna drive over someone's lawn, you're gonna find the next open area to a street or a roadway. That's just not gonna
We
work.
would
That's why we have definitive plans that get approved and reviewed.
We would present a detail, if the board is inclined to ask us to create an emergency egress, we will create that emergency egress, and we will design it in accordance to the fire chief comments and so forth, and submit that detail to the board for their review and peer review, et cetera. If the board feels that a secondary means of egress is not necessary, then this plan would stand. So we're prepared to, I mean, I think a secondary means of, personally, myself, I think it's required. It should be.
Somebody in their right mind would say, no, if I'm going to give you another means of egress, of course.
Yeah,
For
yeah.
147 years. I mean, if I'm not mistaken, the southeast lot, that L-shaped lot, is that the one that would, I mean, all you have to do is just extend from the cul-de-sac and give like a 20-foot easement into that lot, and you're right on Fairway.
There would be no easement required. The roadway would,
We have frontage on.
No, I'm saying for that lot, later on, when you sell that lot, will be another 20-foot,
No, they don't own that lot, the one at the bottom, they don't own that one.
Hold on a minute.
Correct.
Talking about two different
Show them
things.
part of the,
Correct,
this
we
is what
don't.
I'm.
You got a better shot.
So we have frontage going all the way.
All right, they,
all the way
okay.
there. So we're not touching that L shape, that lot, we're not touching that lot.
They don't own that. Mr. Chair,
Yes,
would you mind
absolutely.
if I jump in here? The fire department can speak to how an emergency access would be needed to be laid out, you know, whatever the, right, the technical, how you create it, how it appears on the ground, that is the purview. The fire department cannot give them legal access onto a private way. You were correct when you said in an emergency, if a designated means of access is blocked, a fire department's gonna do anything they need to do to get to the people who need their help. However, they have not, their counsel stated at one of the first hearings, maybe the second hearing, that he would provide a legal memo as to they are evidence that they have the right to access Fairway Drive. As I understand it, Fairway Drive is a private driveway. I do not believe it's even a subdivision road. It is just the driveway into a condominium. So they don't have, just because they have frontage on Fairway Drive, or they don't even have frontage, because that's a legal term, they abut Fairway Drive. You only obtain legal access to a street if it is an approved, it's an existing roadway, a subdivision roadway, it's a way in existence. It's not, it's a driveway. So they're conflating what the fire department would say, hey, listen, yeah, great, if we need to come in there, this is, and you guys can put down gravel, whatever the heck they want it to look like. The fire chief, the fire department can say that. That does not bestow on the owner of the development parcel the right to create that as public access. So I just wanted to confirm my understanding of the law is the same as yours, Mr. Chair, that they need to provide legal evidence that they have. I actually had this exact situation in another 40B that I represented a different zoning board, and where someone claimed something similar, and the abutters went to court and the developer lost. So there needs to be some written evidence, legal evidence, case law, that they have the right to access this roadway. And they promised it months ago, and they have not yet provided it.
All right, so are you
If I may-
saying that, excuse me, just one sec. Are you saying that Fairway Drive is not a public way?
No, it's the driveway into the condominium.
That plan says public on it the last time I just, if I can see.
No.
Hold on, what it may not be, but what does it say on that plan?
It says public.
Yeah, that could be wrong.
Mr.
No, that's okay.
It'd be an innocent mistake.
I've lived
Mr.
in
Chairman,
this
if I
town
may
most of my life,
respond.
and I did not know that Fairway Drive was a private way. But I'm not here to make the case for them, and I'm gonna give you an opportunity to speak.
We will, we're not gonna solve this tonight. We can go back and forth. None of us are attorneys, not on this side, so.
There's three of us here.
Legal opinion, our attorney's not here, so he will respond. I will say, he said he was gonna provide the memo if we were using it for our vehicles.
That's correct.
So that was misstated. But, either case, we will get to the bottom of it. It is important to know that Fairway Drive does have Cape Cod berm, and we could put in a gravel road right through our grass area. If you've been to the site, that whole area that we own is grass. That would be done in accordance with the fire department for a gravel road, so the trucks could jump over the curb. So we wouldn't need a curb cut. It wouldn't be necessary. That's a lot of reasons why Dartmouth has Cape Cod berms. But let's move on, because I think it's a waste of time for us to keep
Commissioner,
talking.
Did you wanna add anything?
I just want to add
Right, but
one
I
issue.
think we should at least, by the next hearing, have resolved whether or not Fairway Drive is something that you have access to.
We don't have access to Fairway Drive, okay? And originally, we were talking about having, as Christian just indicated, that would be for a second egress, not a secondary means of egress. And at that time, we indicated we would get a memo, and we have since acknowledged that Fairway Drive is not technically a public way. So therefore, we could not have traffic go out onto Fairway Drive from our development. So we no longer are taking the position that we have legal access. However, we are taking the position that the property line, and as Christian said, if you go there and you can see the grass that we have, it goes right up to that Cape Cod berm. And it immediately abuts Fairway Drive. So we're just asking, or the fire chief is asking, that be a emergency means of egress, which they have indicated to me, District 1 chief has indicated to me, that they would have the right to access the development. And council is correct in indicating that there's nothing in 40B that requires the plans to be 20, 30, 40, or 50%. The regulations only refer to preliminary set of plans that give enough information to the board to make an intelligent decision regarding the permit. It talks about preliminary, very similar to a planning board. When I go to a planning board, we submit a preliminary set of plans. Those plans are then acted upon by the planning board. They make a decision, and in that decision, they require what we refer to as a complete set of plans, a definitive set of plans. And this process is very similar, except it's much more detailed that's presented to the board.
Thank you.
Thank you.
Mr. Chair, can I,
Certainly.
if you don't mind, I just want to, so thank you, Mr. Cussom, for the clarification on the percentage, and he did state it. The plans need to have enough information for the board to understand the impacts of the project in order to even formulate the appropriate conditions. And I think that's the question from Mr. Gabriel's review as to whether or not you're actually there. I would suggest that something like an existing conditions plan, which is supposed to be a survey, there's a whole list, there's no meets and bounds. Like there's something like an existing conditions plan, that doesn't need to be developed later, but yet it's missing significant information that every existing conditions plan for every project and every 40B should have. So there is information that has not been included. You know, the meets and bounds of the parcel is not shown, there's setbacks not shown. There's a lot of information that's relevant to the board's ability to evaluate it, and I think Mr. Gabriel's has laid that all out. And so I think, you know, that's the kind of give and take here.
And that's all stuff that they can amend, right? That's
Right,
all, those are all
yeah.
things that they can amend. I just think that earlier rather than later, it should be determined as to where this emergency access or exit is going to be designated. If it's going to be here or somewhere else. I think that should be determined at some point. I'm not here to argue for them, but, you know, just because it's designated a private way doesn't mean that they don't have any access to that roadway. Because they have frontage, they may have certain rights that attach.
No, he's just acknowledged on the record that they have no legal rights.
When you say no.
Well, no legal rights, in my opinion, to access that on a conventional basis where there is no emergency egress, is just a secondary egress. So I don't think we have the legal right to have cars go out onto Fairway Drive and then out onto Tucker Road. That's what I'm referring to. So we're not proposing that at all. We have eliminated it in the very initial meeting. We discussed that, and that's where the idea came up about getting a legal opinion. And even though there may be some town services that are being provided to the residents in a private development, I'm still saying that we acknowledge that we do not have the right to bring the cars out onto Fairway Drive. However, the property line abuts Fairway Drive, and we have frontage. Look at the frontage that we have on Fairway Drive.
It doesn't.
Let me finish. So I'm just saying that, and we're not proposing any, the only thing we're proposing is the emergency egress, and that would be the location, Mr. Chairman, of the emergency egress.
I would suggest that, as I stated, with all respect to the fire chief and what he spoke to as what he would need if it was the emergency access, totally defer to the fire chiefs with respect to that. However, I believe that there should be a legal memorandum from the applicant's counsel that's case law, not what a fire engine's allowed to do in an exigent, you know, like you said, exigent situation. Case law that says that a brand-new development, subdivision or otherwise, has the right to designate a emergency access for fire trucks that goes onto land, privately owned land, and that street is private owned. That is private land. It's a street, but it's privately owned land, owned by the condominium association. So they have not provided legal basis, legal documentation, a statute, case law, that they can designate that on a new development plan as their emergency access. I have never seen it in 30 years. So, I would recommend that the board request that legal evidence.
We'll be glad to, Mr. Chairman, we'd be glad to refer to council on that particular issue.
I think it's important for both you and
Sure.
us to know, because if you can't do it there, then you're gonna find another location.
I also have 30 years of experience, and we've done that in several developments under 40B. But we'll refer this to legal counsel so that he can hopefully provide the proper memo that the
All right.
board should be,
That would be
is
definitely be
entitled to.
helpful in moving forward with this issue.
I'll look on-
All
I'll
right,
look at this.
gentlemen, is there anything else? You don't, just before I go there, is there anything else you'd like to add, Mr. Farland? Okay,
I have a question.
sure.
How did you,
To Mr. Farland or to Mr.?
Mr. Farland, how have you changed the number of single units and duplex units now that you're down to 138? Do you,
Let me go back to the other drawing. Easy. So,
I'm just looking for a number.
the total number?
The total number of singles and the total number of duplexes, now that the total is now 138.
Christian, just go back to the plan that shows the
Yeah,
duplexes.
I think it's gonna be on.
Mr. Farland, if you don't have it, you can just tell us you're gonna get
Oh,
it.
we
to
have,
us
it's
next
on the
time.
plan.
You have it? Okay.
The duplexes previously on the initial plan had 15 buildings, 30 units.
15 duplexes.
15 duplex buildings for a total of 30 units was on the original plan. And this plan,
Yeah, I don't think
I
it's.
think,
what it is.
there it is. So it has 1, 2, 3, sorry, want to take that out. I'm trying to count. 1, 2, 3, 4, 5, 6, 7, 8, 9. That particular plan has 9 duplex buildings, 18 units. So we have, if you want to do the math,
14 duplexes,
14?
yeah.
So there's 14
28.
from 138. So we have, if my math is right, we have 124 single-family and 14, no, that's 14.
It would be 110, right? 28, 138 minus 28
18.
is 110.
I'm sorry, I'm
We can
counting.
put it on the cover sheet for you.
All right, so that's fine. But I'd rather not guess, right? But it doesn't mean that you reduced the number, doesn't necessarily mean you did all the other calculations that follow through. I get that.
6, 7, 8, 9, so the 9 building, 18.
Excuse me, miss. Ken, other gets all picked up on this.
We will get you the exact, we'll get you the exact number, but I believe it's 138 units, of which 18 are duplexes, and the rest are single-family of 120, for a total of 138 units.
Okay.
But we will get you the math.
Anyone else on the board have any questions?
No.
Later, probably for Mr. Gabriel, I just wanted to see if he feels that the submitted plans meet the requirement of preliminary plans, that we can make a decision based on that, so.
Okay.
We don't
Well-
get into, if he's far into it, and then we need another 10% of details or 20% details, we don't need to do that at this time, that's what I'm saying, so.
So, we'll call them back up, but
Yeah.
there's some people raising their hands. I want to give them an opportunity to speak. I'm going to ask that if you kind of come forward, not necessarily statements at this point, if you've got any questions, so that we can either have them address them today, or take notes so they can address them the next time we're here. And also, our expert, our peer review expert, will be able to listen to what these questions may be, and they may be able to address them as well. So I see a hand up. This lady with the red, I saw her first, Miss Miller. I'm going to ask her to come up first. Yes, you. And then Miss Miller's next.
Diane Kiltica, 39 Bayberry Lane. Could you point out where you get 9 duplexes down there?
There's 14.
He believes that there's 14, but they're not.
14, they're all down in this area right down here.
Right, but didn't you say you've reduced them?
We did. Before there were 15.
So you reduced one,
That's correct.
really? And that all adds up properly
Adds up properly for what?
for the reduction
We
from
went
one?
from
Oh,
147.
we're gonna change, hold on, just one sec.
138.
Mr. Fallon, one sec. You have to direct the questions to me.
Did that all add up from 147 to 138?
Here's what no, so let me just say this. I think there's some fewer single-family units as well that they took away.
Didn't you ask them that question as well?
I don't know if I did, but the thing is this, out of fairness to them, I'm gonna give them an opportunity to check their numbers, so that the next time they come before us, they're gonna tell us exactly, with confirmation, how many duplex units and how many single-family units that are actually being proposed.
Okay,
Is that okay?
so, question two.
Question two.
We've been here from the beginning, and we keep hearing about the fire chief. Hasn't anyone provided him an invitation to come to speak? They keep referring to an email.
So they have an obligation to present to us something that we feel is appropriate and meets the requirements of a 40B approval. If it ever gets to the point where we have that question, we will bring him here. I haven't seen anything that shows me a designation, or any one of our members here, a designation as to where on that cul-de-sac they propose to put it. I get a sense of where it's gonna be, and also how wide it's gonna be, what the composition of the roadway is gonna be, what type of a gate is going to be there. If it's gonna be a breakaway gate, if it's gonna be an electric gate, a manual gate, I don't know what it is. How commercial it's gonna look in relation to, the character of that area of the neighborhood. Obviously, we wanna minimize the impact of this. I haven't seen anything that shows me what that is or where it is exactly. That's why we're here to gather that information. So I think them having heard your question, having heard my follow-up on that, hopefully they can address that the next time with something. First, making a determination if they can actually access the roadway from a legal standpoint with some sort of authority. And when I say authority, either case law or statute, or some treatise, if you will, that says that that's allowable. And then number two, where it's going to be and the extent of how wide or the length or whatever, the other specifics. What do you refer to it? The technical part of it, okay?
Thank you.
You're very welcome. Ms. Miller, Mrs. Miller, I should say.
We won't tell my husband.
All right.
Lori Ann Miller, 318 Bakerville Road. I am here as a private citizen and not a member of the planning board. I want to repeat that again. I'm here as a private citizen. I have looked at the original plans, so I'm not sure if my questions are still going to be the same. Where is your location of your post drop-off, your postal mail? And on the original plan, there was a bus drop-off. Is that for the school kids? Is it still on the same plan here? And do you still only have like 8 parking spaces for the mail?
All right, so.
And I have another question too after.
Let's start with one.
Okay.
Can you answer that, Mr. Farland?
Sure can.
Okay.
So again, this is the area we're proposing to have the mail, is right near the entrance. This will be a standalone building, which will have PO boxes in it. And there is currently 10 parking spaces right there for the mail. And then there is a bus shelter located right here.
And if I look at that parking area, it seems to be a wide white one. Is that for handicap accessibility?
Yes.
Okay.
Can I continue?
Yeah. What is that? Yeah, he addressed both, the drop-off and the postal.
Right.
Next question.
I may be wrong, but I think most people pick up their mail first thing in the morning, going to work, or on their way home at night. 10 parking spaces is not going to be enough for approximately 38 boxes, because they're all going to have boxes. You're going to have a traffic jam there for 2 reasons. That's the school bus drop-off. So the buses are going to come in to pick up their students. And if anybody drives by where kids are being dropped off in the morning for the school buses, you see 4 and 5 and 6 cars there, because the parents are sitting in the car waiting for the bus to come to pick up their students. I know, I take my grandkids to the bus stop. Same thing when they come home in the afternoon, 4 or 5 cars, because the parents are there to pick up the students, or the babysitter, or the nanny, or whatever, the grandparent, usually. I talk with a lot of grandparents. So I think there's going to be a traffic jam at that cul-de-sac, because you're going to have mail pickup, you're going to have students pick up and students drop off. So you're going to have a problem with not enough parking there. They're going to be parking heading towards Tucker Road. They're going to be heading towards the intersection. That's not a good scenario for that area. Now, my next question is, and I didn't have, because this is a whole brand-new plan, is your detention ponds. They're right in the middle of housing. So what is the depth of the detention pond? What's the curvature? Are they built out for a 100-year storm or more? And are you going to put fencing around them? Because this area is definitely going to have children in it. And a 100-year storm or more, which we seem to get a lot of them, is not going to drain overnight. I've seen other detention ponds that don't drain overnight. So unless you have some real good drainage there, these detention ponds, especially down at the lower end, the west end, are going to drain at what percentage?
Right, anything else?
That's it. So
All right,
the
so-
traffic congestion and the detention ponds. Thank you.
Thank you. All right, so I guess the issue is she doesn't feel that there's enough parking spaces for the mail pickup, and also worried about the congestion between the proximity of the mail pickup in relation to the bus drop-off and pickup area. Any thoughts about that?
I mean, we can take a look at it, but this is standard number of parking spaces for a typical 40B development.
It's easy, you've got plenty of land there where you could add more if you needed to.
You could add more if we wanted
Could add
to,
more.
but again, you're introducing more impervious area, which we're trying to minimize.
I get it.
It's something we can look into. I think, you know, if they're dropping their kids off for the bus, most likely they're gonna grab their mail when they're there too, so. And again, we have walking, there's sidewalks around the entire development, so hopefully some people enjoy walking and to get their mail as well. But we'll look at it.
Mr. Chairman, if I may.
Sure.
This is one of the only developments in Dartmouth that have even provided this type of ability for a bus stop with a shelter for the children, and also for this type of mail. And if you take a look at Fairway Drive, there's nothing there. If you take a look at Peyton Aram Acres, there's nothing there. You take a look at many of the developments in town. Now, we went to great lengths with our landscape architect to come up with an amenity area that allows for not only stopping and getting your mail, but getting out and turning around. And so if additional parking is necessary, we do have some additional area, and that would not be a problem. That would be a decision for the board to make. And we also have additional parking, if you can see to, I guess that would be sort of the south side of the pool area. And the distance between that parking area and the other is, you know, I don't know, a few hundred feet. So there's also additional parking to the south of the pool area. So if the board requires additional parking, it's no problem.
Thank you.
Can I correct that statement?
Come on up.
Mr. Fallon, you can attest to this. The subdivision you just put in across the street from me, it has those post box at it. This is something that is now required by the postal system, whether it's a 40B or a regular subdivision. They require that you have boxes. I mean, they're doing it on a two-unit subdivision. They want the boxes together because they're trying to save money on gas.
Okay.
Yeah, I think,
Mr. Chair, may I ask you a question?
Sure.
And it's a question, a town of Dartmouth question. In many communities that I've worked in on permitting issues, the school department or the public school buses will not go into private developments. They pick up at the street, and they will not drive in. So I guess the question is whether or not that's even the right location for a school bus pickup, because typically they will not go into private development. So I think it's just, and I don't know the answer for Dartmouth, I just think it's something worth understanding whether or not a school bus would even pull into this development, or whether they have to address something at the street for some sort of turn-in for a bus or something along their frontage there. But I don't know the answer to that in Dartmouth, so I just wanted to ask a question.
That's actually a good point. And we intentionally created an area that's much more safe, okay? If the school department or if a Tremblay bus, okay, would stop right at the entrance, that creates
I agree. I think it makes more sense
So
having
we
it on
would
the property.
encourage, and I would suggest that the Board of Selectmen also encourage the school department and Tremblay. And that's one of the reasons we also created the turnaround, that turnaround. So a bus, they can stop right at the bus shelter, spin around that cul-de-sac, which meets the turning radius requirements, out onto Tucker Road. So I would think that's what would happen eventually. If they want to keep it the way it is, I don't think it should be.
Thank you. All right, I think this lady right here, I'll get to you. She's been asking, come on up. You want to say something? Yes, yeah. If you could just identify yourself, please.
Couldn't tell if you were pointing to me or this person behind me. My name is Kate Dabney, 82 Fairway Drive. I'm not sure whether you hinted at an answer to my question, but I'd like to ask it directly. When we talk about the emergency access from a private road, that's fine if the developers, it all goes through and the developers say they're going to provide this. What on a daily basis is going to prevent residents saying, I can't wait as long as it's going to take me to get out on the regular entrance, I'm just going to take the Fairway Drive entrance? Do we have to stand out there and monitor? Do we have to file,
What I have seen before is they have breakaway gates, so there's a gate that's there, but for emergency purposes, it's set up and structured so that the fire department's apparatus they just drive right through them and they open up.
So it would not be accessible 24/7 and
Not be accessible. That's not what they did, and that's not what we approved on the preserve up in Dartmouth, up in, off of State Road, across the street from Cask and Pig. That's
Okay.
how it is going on to Reed Road.
Okay.
They have a breakaway there on Reed Road. Does that sound right to you?
Yes.
Yeah.
Thank you.
That was my right. That was before the pandemic, right? Wasn't it that we approved that?
Oh, during.
It was during, yeah.
I forget. I got confused. The pandemic's thrown all that off. All right. Hold on. That lady in the back wanted to go. I'll follow up with you. 1 second. Give her a chance.
Hello, Liz Richter, 960 Tucker Road. I noticed that there's a number of water detention basins.
Sorry.
kind of-
Can you just speak into the microphone because I can't hear you?
Sorry,
All right.
I'm very tall. A lot of water detention basins towards like the north and the west, but I don't see any on the east side. So I live on the east side, and I know that when the country club was originally built, there were a lot of drainage issues causing issues for the homes that are parallel to Tucker Road. So I'm wondering what they're going to do about water runoff affecting those homes, that there is definitely a downgrade into those properties. I think that's an important
I do
issue.
know this. I know that the topography of it drops dramatically from the front near Tucker Road coming all the way back towards the back of the property.
Absolutely.
So there's a natural slope going west on that property.
Absolutely, but that's like starting at the property line of Hawthorne. At that property line, it drops down, if you're facing east, it drops down into the properties that are parallel to Tucker.
So
that would cause and has
You're
caused.
concerned about that. Mr. Farland?
Yeah, the stormwater calculations demonstrate the post-development, especially in this area. That was an area that we wanted to really look at because a portion of that does drain onto the back of those properties. But we designed it in a way where there's going to be less water going there now than what was previously there before. So that's really was a simple
I would love to see that
solution.
detailed. I don't, doesn't,
We have a
If you
peer review.
look at the
we have a
grading
peer review
plans-
person, so we're going to be able to ask him that question,
Take a
okay?
look at that.
and my other question is more of a general question. some of these meetings feel a bit like stalling on behalf of the developers. And I've, just hearsay, I've heard that there's a deadline, that they have a certain amount of time to present to the board before they can kind of just go right ahead and start their project. So I just wanted to ask for clarification on that policy that you guys have within the 40B plan. Is that?
That's not our policy.
Okay.
That's state law that puts
Yeah.
the requirements, and that's the lady that's going to answer that question for you right now.
Okay.
And then that's something that it's also on the notes to discuss kind of at the end what the schedule is. But there's 180 days. Right now, this hearing, unless it's extended with the consent of the applicant, has to be completed by February 23rd.
Okay.
So that would be the last date that the board could take in any new information.
Okay.
After that, the board has more time to review everything and deliberate and issue whatever decision that they choose to. But right now, the deadline is February.
Okay, and is it ensured that all of the important topics will be covered by then? Or is it kind of like if some don't get, spoken about by that time, that they just kind of fall off? How does that? I'm just curious because there's so many other environmental concerns and, so many other concerns as well.
I think that that's the topic of the open issues that haven't been covered yet, and the schedule for covering those is something I think the board may take up before you close the meeting tonight.
Yes, we're going to discuss some of that.
Okay, thank you.
Chairman, Mr. Chairman, I have a question to the
Sure.
board, if I may. I've been hearing a lot of conversation about a private way and the emergency and the fire chief. I think we should have gotten something by now, but it's a private way unless I'm misreading the law. What happens if the people that own that private way decide, and Mr. Chairman, you talk about putting a breakaway fence so the fire engines can go through for emergency purposes. What happens if those people decide to put elm trees there and they put some screening material? Does this board have the authority to stop them from improving their private way?
I don't think we do, but I don't know whether or not, how this road is specifically designated.
Well, it says designated as a private way.
Well, the plan I just saw there said public, okay? But.
Not our plan, that's
Okay.
not what the.
All right, I get.
That's not what the
I'm
town.
not arguing for them, all right,
Yeah.
not arguing for them, it's just, at some point, we're gonna get a legal opinion that's gonna tell us whether or not that they can use that area for, and I think they ought to figure this out sooner rather than later, because we're gonna have to change the plans. Because if they can't exit from this area, they're gonna have to find another location.
That's what I'm concerned
That's gonna
about. is
change the
what if we
layout.
if we get a legal opinion that says that they can access that property, does that mean if the people that own it, they're not parties to this, if they decide they wanted to plant elm trees there for shading, does that mean we have the authority to stop them? I doubt it.
Yeah, or to put a fence or anything else along
any
their
type
own
of
property
shade,
line,
yeah.
right? It's their own property line.
Mr.
I'm assuming
Chairman, if I may.
those people want some type of privacy too. They might put arborvitaes or elm trees. We have no control over that.
I'm not an attorney, but I will tell you, Massachusetts has a fire code, 527, where private owners cannot block emergency access.
There's no emergency access there.
I think,
If there is one, there is not one right now, but if there is one, they cannot block it.
It's,
okay, hold on.
Again, we're talking about something.
But not only that, you guys have a lawyer, your lawyer's gonna provide us a memorandum, and then at
he
that
own
point,
right
we
up
can
to the
decide
road?
whether or not we would adopt it or not, or maybe seek another opinion, and then we can go from there. Fair enough?
It is, but in
We're not gonna
response,
resolve that issue tonight. I think we can all agree, we're not gonna resolve that issue tonight.
correct, but in response to the question is that the planning board had approved the layout for Fairway Drive. You can't change that without going to the planning board for a change. So if you want to do something on that Fairway Drive, planting arborvitaes, that would, but there again, we're going to get that legal opinion.
All right, thank you. All right. All right, so I did open up to some public comment. I'm gonna let one more person, I'm gonna let you come and speak, and then we're gonna close this up for, well, we're gonna speak to the, our peer review expert just for a final comment. You can come up, sir. You wait your hand. Come on up. Please identify yourself, name and address.
I just have a, Dennis Manor. I live on Hyacinth, on the 7th green of their property line.
Okay.
Okay? My question is this: if it's not private, does the town owe us money for all the garbage pickup and the snow removal? Because we pay for that because it's private. So if they're saying it's a public road, are you going to pay us back for all the money that we spend?
No one, I don't think anyone's saying it's definitively public. It seems to me it's leaning more towards definitively private. We're gonna find out at some point, and then we'll probably have that answer. I think it's been impressed upon them now that they're gonna have an answer to this. It's coming to a head, okay?
Okay, and my second question is, since I live on the 7th fairway, it's very high there. There's a 15-foot drop. Could you tell me how you're going to excavate that so that there could be a house behind the property line? I don't understand how are you going to just tear that down to get 15 feet?
There's several retaining walls that are proposed within the development.
So now you're talking about
Hold on,
walls
let him
that
finish.
you never talked about before?
Hold on, let him finish.
About walls if you
Hold on,
want.
that's why you gotta ask me the questions.
Okay, all right.
Otherwise, this doesn't work. It gets adversarial, and it doesn't work.
Okay, you heard the question.
We're gonna have dialogue. You ask me, then I turn to him, okay?
Okay, you heard the question?
I heard the question.
Okay.
And I think he heard it too, and I heard for the first time, retaining walls. So we're gonna see what he's gonna tell us. I don't know if you know specifically where the 7th green is. I don't know where the 7th green is. What's your address?
54 Hyacinth Drive.
54 Hyacinth Drive,
That's the 7th. The 7th, not the green, it's the tee box.
T-box. Okay.
Okay, that's a 15-foot drop. That tee box,
Sir,
it's a 15-foot drop.
okay.
So I want to know how you're going to knock that down.
Just, Mr. Chairman, just so all the abutters know, the plan set is public record. There's 33 sheets. Grading plans are certainly one of them. So it shows the existing topography and proposed topography. So if anybody has.
Do you know where he's located specifically? And if you can't answer that question today, that's fine. It's fair that you
I
can't.
can go over the grading with them because it's all,
But do you know where Hyacinth Street is and where the specific lot is?
I do not.
Hyacinth Drive.
Hyacinth Drive, excuse me. I don't know where it is.
It runs off a fairway,
Okay,
okay?
that helps me. Mr. Farland, I think it's unfair,
Is it-
I think it's unfair to ask such a specific question and expect you to have a response.
Well, we have
right
the
at
plans here, so if he,
Okay,
which house is yours?
54, it's next to the last house.
Is it this
I
this
can't.
house right here?
Where's that dot? Yeah, that's it.
So the slope's down 3 to 1 here. This is all proposed grading.
That's significant.
Let me zoom in. It's a large file, so it takes a little bit. So these are all 3 to 1. These are all 3 to 1 contours here.
I don't know what that is. Okay, yeah, I'm looking at you.
So a slope, you're cutting down, you're cutting it down, so
Mr. Farland,
you're going,
me and you. Explain it.
yep.
Okay.
So you're going down a slope 3 to 1. So you're going 3 feet, you're going down 1. So it's a slope, that's the slope. So you're cutting it down, basically. The plans, again, these.
So for every 3 lateral feet, it drops 1 foot vertically.
This is the grade change here, so it's all grading down towards the roadway.
But I think more importantly, he's concerned with where the end of that slope ends in relation to his property and at what elevation it's going to be in relation to his property.
They match.
And I think that's a legitimate concern, is how much water is gonna come off of that and how much is gonna come onto my property. And if you can't answer that now, I get it.
It's grading away.
It's grading away?
There's no water going onto his property.
Coming this
Oh, so
way.
it's coming, okay, so I
Going
didn't
down,
understand
we're
that.
grading down.
So you're grading down from the north to the south? Okay. So
Yeah,
that
okay,
is gonna
grading
be a grade, and all the water that's there is gonna stay onto the premises and be either put into the drainage system or the detention ponds? That make sense?
Yes.
Did you hear what he said, sir?
I heard what he said, but it doesn't make sense.
All right, well, we're not gonna go beyond that today. So
Okay.
he's described how it's gonna be sloped. All right. Is that it?
That's it, but he didn't answer the question, okay.
All right, but, look, no, we'll follow up on it again if we need to. But I think he's already explained what the slope is, and it slopes away from the property. And I think probably 3-to-1 is something that's acceptable for safety measures, for the amount, for erosion control, and whatever else. But this is the man that can probably answer that if he's concerned, if you're concerned about whether or not you're gonna get an independent opinion on that. That's the last one. Next time we're gonna be here, we're gonna pick it, no, the person behind you, sorry, ma'am. I was looking in that direction. Okay, so let's move on to the next section of what we're gonna do here. We're gonna discuss our hearing schedule. So, as you had indicated earlier, I've been told that the hearing on this is currently required to close by February 23rd. So, when's the next date that we're planning on having some more information on this?
December 19th.
December
I
19th?
think that's what you said, right, Christian, for the engineering?
The response to the.
The response to his suggestions by December 19th. Is that something you can meet, Mr. Fallon?
Yeah, oh yeah.
All right, so December 19th at 6 o'clock.
We're
No,
not meeting.
no,
Hold
that's,
on. Let's see what we got here. I thought no, we picked December 11th.
No,
That's our next
no.
date.
So
All right,
we,
December 19th.
no, that's the date that he's going to submit his
right.
response
Right.
letter to Mr. Gabriel.
All right, so that
letter.
means that we're gonna be in January at this
right,
point.
we're not meeting till January 8th, our
Is that our next
first
date?
meeting. Yeah.
That's what it is. I got it on my calendar.
So is the next meeting is January 8th for this hearing? Is that,
Well, we just have it designated for ZBA for
oh,
a hearing.
oh, okay.
So, it's for a 40B.
Yeah.
And it's at 6. We don't have any other local business, do we, for the 8th? We do at 5 o'clock? Yeah. Okay.
Michelle, would you send me like the dates going forward, just so I can put them on my calendar? Okay, thank you.
Does January 8th work?
Yes.
A peer review, does January 8th work for you?
I'm sorry.
So I'm just looking at the schedule. I'm going to be gone for about a week and a half just after the submission is sent in. Holiday PTO. By January 8th, I should be able to have a review of the plans. I don't know if I'll have a finalized letter by that time.
But you'll be able to provide comment on it.
I'd be able to come here and give verbal comment on it, on what we see. Yep.
But, Mr. Chair, are there 2 dates in January, so that there's one for the other 40B?
22nd.
Okay. Would it be better then to switch them and do this one on January 22nd to give Mr. Gabriel more time?
We're coming up on the 23rd pretty quickly, though.
The 23rd is your deadline
February 23rd. The 23rd of February is coming up.
for
pretty quick.
both 40Bs, is the
The other
February
one,
20th.
I think that they would work on an extension.
Yes.
We have a problem with 22nd, the 8th would be better.
Okay.
Would be better?
All right.
Okay. Does that work for you, Mr. Fallon, as well? All right, so January 8th.
So I have a sort of a general comment regarding the schedule and
Yep.
regarding the closing of the hearing and how you would suggest that we, because once you close the hearing, we
Right.
can, you know what I'm going to say.
Yeah,
So
but-
once you close the hearing, we cannot offer
Right.
any additional information. Many times what happens is that the board likes to go into, I don't know if deliberations is the right word, but to discuss terms and conditions. So it's much more effective if we discuss together terms and conditions, and we can do that in the public meeting. You might say, you know, I'm only going to approve 50 units, and we say, oh, that's a problem, okay? So we can have that discussion back and forth in an open public meeting is what I usually like to do. And if we were to do that, typically, we would have to give an extension to the February 23rd date.
Yep.
in order to allow that time. Because otherwise, you close the hearing, I mean, council's going to tell you this too, but you close the hearing, and once you close the hearing, you have to issue that decision, and you have to
40
record
40
it
days.
within
days.
40 days. You have to record that with the, with the
Well,
Clerk.
Thank you for the logistics on that, but let me ask you, do we
Yeah,
have a
so-
list of all the waivers already that they
No,
seek?
no, so they're going to send an updated waiver. So just to speak to that, right? So if you have a meeting January 8th,
Yes.
then there's another meeting, I don't know what the date would be in February. But at this point, there still needs to be the applicant's response to the peer review and Mr. Gabriel's opportunity to actually review it. He's only going to have a preliminary review of that by January 8th. There are a lot of open issues. There's the open question regarding whether or not the plans are sufficiently detailed for the board to feel that it's ready to make a decision if, and, you know, and if it were to grant it with the conditions, et cetera. The water wastewater, I understand that that letter is forthcoming. Hopefully, today's already Thursday, but hopefully the applicant will have that, hopefully in the first part of next week. And then they'll need to respond, and there'll need to be a discussion about the water and wastewater. There also needs to be a discussion about the waivers. So, you know, to suggest that, you know, all of that can happen on January 8th and another meeting before February 23rd seems a little aggressive. And I guess, you know, it's very atypical for a 40B to get done, but particularly one of this size, and with all of the open issues, to be done within the 180 days. So I guess the question is whether Mr. Cusson is going to agree to extend the hearing to make sure that all of the issues could be heard, because until all of the issues are discussed by the board and myself, staff, is not in a position to start drafting the decision and potential conditions. So, you know, that's the question, is between that, 2 meetings, presumably between now and February 23rd, can all of those issues, can all of the responses happen, you know, the back and forth between the engineers? I mean, I think that's the question for the board, whether you feel like that's feasible, and if not, then the question is whether the applicant is going to hold the board to that February 23rd date.
If I may.
Absolutely.
Sure. Typically, if we think from a developer's point of view, and I've been advised by the applicant, if things seem to be heading in what I would consider the right direction, we're going to be very cooperative in to have many of these issues resolved. Whether it needs an extension, we don't know yet. It may, and if it's heading in the right direction, we'll give you that extension. And when I say heading, so, the waiver, let me just discuss that a little bit. We have prepared a waiver list, and that list it gets amended from time to time. But the whole idea of a waiver list in the beginning is that we don't know enough about the development, all the plans, all the details and so forth, to make a complete waiver list, absolutely including everything that we need. The waiver is, we need all the waivers that are necessary to build the development in accordance to the plans that have been approved. And then, so from a waiver list point of view, I think that that's very doable. I mean, for example, the review that's already been done says, well, you don't comply with the subdivision rules and regulations. Of course we don't. We know that. That's why we're here. So why are they spending time and money to make that kind of a comment and review when we know? So when I say heading in the right direction, those are some of the things that we need. They don't have to spend time and to bother your time and my time and money to say that sort of thing. So it would be good to help for us and for them to maybe zone in on some of the waivers that are required, that hopefully the plans that are presented, those are the waivers that are necessary. That's typically.
We are going to have an updated list too, so it would definitely be a lot more accurate than what it.
Correct.
The initial.
More specific,
Yeah.
right? Much more specific.
Yeah.
The initial plan set we gave you guys, you remember, that was about 20% drawing level. There was were not many details on it, so we didn't, as Mr. Cusson said, we didn't know all the waivers. But now we're at a point, especially after the review consultant did his review, and the plans, the level they're at, to give you a more accurate one, which we plan on having submitted on the 19th. I think that would solve a lot.
And those, again, those are the waivers based on the plan that we're asking for you to approve.
So, Mr. Chair, there is a document called the Chapter 40B Handbook for Zoning Boards of Appeals. It was issued by all of the subsidizing agencies by the state that give, including Mass Housing, which gave Mr. Cusson his site eligibility letter. And it states that zoning boards, and in fact, they highlighted it
Say that
in
we
red.
shouldn't take blanket waivers, right?
Yep, it's a developer's responsibility to identify the waivers needed in order to building the project. As a rule, the ZBA should not grant what is commonly known as a plan waiver or a blanket waiver to accommodate conditions that may be apparent on the plan but not specifically identified in a list of waivers requested by the developer. And it was noted from the first hearing, or in fact, it was noted in the original letter, I believe, that Mr. Vitale sent to the applicant, that their waiver list was predominantly all blanket waivers, and that pursuant to the guidelines issued to zoning boards by all the subsidizing agencies, ZBA should not be granting those types of blanket waivers. And so I would disagree with Mr. Cusson's representation on that front.
I'm not sure I maybe explained it properly. Okay, we're not asking for blanket waivers. We may have, in the initial stage, as Christian said, the plans were at best at a
We
20.
know what we need. We need specific waivers. He said he's gonna provide them to us. Then we'll have our person look at it and make sure that it meets the requirements.
Correct.
Because we don't wanna put you in a position where you gotta come back and do, just because of one little thing that failed to be in there. So we make sure it's inclusive, all right?
Correct. We're doing the best
Okay.
we can in that
That's fine.
regard.
We can work through that. We'll go through it. All right, so, is there anything else I need to address here tonight? I still need that gentleman, he's got a comment I need to make.
Just to see where we
I'm
stand.
gonna ask you to step down if our peer review expert could come forward. I think there was a question that was posed earlier. What was it again that we were gonna ask him?
What stage does he feel we're at with the plans?
There you go, that's right.
I mean, we don't need to be 90, 100%, and certainly we're not at 25%. Do we have enough information that you feel that you can recommend approval or denial or whatever it is, you know?
I'm just gonna piggyback on that, 1 second. So your review of all this, it was of this most recent plan with 138 units?
Correct.
Good, okay, continue.
Oh, yeah. So to answer your question, yeah, no, I believe at this point, based on what I have in the peer review letter, there's still some more information that needs to come back to be able to say that these should be recommended for approval.
So when you say more information, you need more detailed plans, or there needs to be more answers that have nothing to do with the plan itself, but more of descriptions?
One basic example is just in regards to the waiver request, because there are a couple blanket waiver requests in there. So that information needs to be listed out in detail as to what exactly they want. So that's just an example.
And he's indicated
he's
that he
gonna do
was gonna
that.
provide
Yes,
that. Okay.
exactly.
All right.
Mr. Chair, if I may?
Sure.
May I ask the peer review consultant when he is taking off for vacation? Because what I would like to do is, even if I can get my letter a little bit sooner, I think it would help expedite it if we can just sit down, engineer to engineer, and just go through the list. If a board member wants to be on, I mean, we can do it via Zoom.
No, I let the experts work with each other.
I think that would be a great idea.
Are you willing to share that with him? You don't have to do it publicly, but before we leave here tonight.
Sorry, what was your question there?
Whether or not you would share with him when you're leaving on vacation so that he can have an opportunity to make sure that he does so before.
Yeah, absolutely. I mean, I'm heading out on Christmas Eve because my kids are getting off for school, and I'm going to spend some time with them over the holiday.
But I mean, the
That
19th,
said,
if we could meet on the 19th, or maybe I have my letter, majority of it done 18th or 17th, I think it would be great if we can have a, one-on-one Zoom.
Mr. Chair, I agree. I think that it's always great for engineers to speak together, and I'm happy to do that.
Right, I
Yep.
asked that the two of you be able to do that.
Yeah, absolutely.
All right,
That's good.
good. Susan, is there anything else I need to address? And don't be shy.
No, I think at the January 8th meeting, I think then the timing is going to become the critical issue. I guess at the next meeting,
We'll know more.
yeah, at the next meeting, no more. I guess for the next meeting, maybe follow up or update on all the civil engineering from Mr. Gabriel. Also, if the water, stormwater letter comes in and is able to get to Mr. Cussin's team, hopefully in the next week, then maybe that can get addressed on the 8th too, and try to get some of these issues addressed that need to be covered. I don't know, it'll depend on obviously when he gets the letter, but that would probably be good. And then, I think these discussions are all going to inform, as Mr. Cussin, Mr. Farland said, what their ultimate waiver list is going to look like.
Okay.
So,
I did say no more. We'll save it for the next time. But is there something significant that you think could assist us here?
Just want to ask quickly, not a comment, just a comment. Chuck Resident, 4/8 Green Drive. The meeting, last meeting we had on.
It's all right. You're going to have to come to the podium. I just wanted to keep it short, but come up to the podium.
Chuck Resident, 4/8 Green Drive. The meeting that we had discussing traffic, at the end of the meeting, the traffic, the consultant mentioned, our traffic consultant mentioned that the standards that the proposer had used were out of date, and asked him to refigure his numbers based on the new state standards. And I was curious if that was ever done.
They did.
Thank you.
So they did, okay. Well, we're going to have another opportunity to speak about that as well.
Mr. Chair, if it's okay between now and when we're preparing for the January 8th meeting, if I could work with Michelle and the town administrator's office, and then we can communicate with the applicant's team and come up with what topics everybody's ready to talk about on the
fine with
8th.
me.
Is that okay? All right.
Absolutely.
Okay.
Absolutely. We don't need a vote for that either.
No. Okay, thank you.
All right, so, gentlemen, at this point, if there's no other business to discuss, I'll entertain a motion to adjourn. Everyone knows that we're on for the next date for this particular hearing.
We need to,
Is for-
January 8th.
Yeah, well,
Make a motion.
yeah, we make a motion. But I'll let them know that that's what we're moving towards. All right, gentlemen.
I make a motion that we continue comprehensive permit ZCMP 25-1 to January 8th, 2026.
Second that motion.
All in favor? Aye. Aye, the ayes have it. So we're all on notice, January 8th, 2026
6
at
o'clock
6
for them.
o'clock.
I'll put them here.
6 in this office, this room. All right, any other business we need to discuss, gentlemen? I asked, we're still in session. We're still in session. We're still in session, sir. Well, I thank you very much. Thank you for the vote of confidence. Anyway, gentlemen, I'm going to need a motion to
There's
adjourn.
still a public hearing going on.
Make a
You're
motion.
up there on the screen, so please.
Motion to adjourn.
I second that motion.
All in favor?
Aye.
Aye, the ayes have it.
Now we can